Mention tomorrow. Yeah. Okay. Yeah.
Supplementary list, item number 1.
Proceedings report, which is received about the death of the appellant, 5 appellants, 47 I have.
In 47.
47.
47 तो हमरो
already
अपडेट ही जाइए ना
एक
आ गोटे 7
ପାଞ୍ଚ
प्लस କିନ୍ତୁ ମିଶେଇ ସବୁ
तीन 5 6 ଆଉ ଗୋଟେ ଖାଲି
ସାତଟା ମିଶେଇ ଦେଇ
ହଁ,
ଠିକ
ଠିକ
ଅଛି।
ଅଛି ହଁ।
ସବୁ ଏଇ ଗୋଟା କଥା ଆଉ
ବାସ୍
6ଟା ତ ଇଏ ହେଇଗଲା ଆମର ଲିଗାଲ ଏୟାର
ସବଷ୍ଟିଟ୍ୟୁଟ ହେଇଗଲେ
ଖାଲି 7 ନମ୍ବର
ମିଶେଇ ଦେଇ ଦେଇଛନ୍ତି ସବୁ।
ଠିକ ଅଛି ମିସିଂ ଦିଅନ୍ତୁ once the
ଏକ
order has
ଆଉ
been
4 ଆମେ ତ
order has already been passed that
ଆଜ୍ଞା।
it is appeal appeals no further is necessary ଏଟା ଖାଲି ଲେଖନ୍ତୁ 7 ନମ୍ବର କୋଉଟା
ମଧୁ
ମଧୁ
in 5 serial number 5.
ପ୍ରଧାନ expired on 36/2024 ଦେଇଛନ୍ତି ତ ଡେଥ୍ ସାର୍ଟିଫିକେଟ
ଆଜ୍ଞା ହଁ
ହଁ ଦେଖିଲୁ ଯେ ଜଣେ ଏଟା ହଉଛି criminal appeal number 46 of 1998 ହେଲା। The London Council for the State has produced the written instructions dated 9/7/2025 received from the inspector in charge, Saranpur Police Station, Nayagarh, that the appellant number 7, Madhu Pradhan, has expired on 36/2024, and to that effect, the death certificate has also been filed, which are taken on report. There is when no one has preferred any application under the provisions of section 394 bracket 2 proviso to section 394 to CRPC to continue the appeal in respect of the appellant number 7. Accordingly, the appeal so far as appellant number 7 is concerned stands as yeah. Yes, Mr. Dhawal.
My lord. Last brief yesterday, my lord, we are using points, my lord, to the effect that this PWs so-called eyewitnesses PWs 1, 5, and 6, whether they can be believed or not, my lord. My lord, if they would be believed, there is no case for the defense. And if there will be any suspicion about their presence at the spot and they have stated whatever they have stated, they have seen it, then prosecution will take into prove the case beyond all reasonable doubt. Here, my lord, PW6, as we have stated, my lord, and as PW6 has stated, he has been examined after 5 days of the occurrence. Question crops up, and he has not assigned any reason why he has not disclosed the occurrence before the investigating officer, though the investigating officer was present in the village. He was quite aware of the same. And PW5 has categorically stated in cross-examination that PW9, the investigating officer, was coming to the village continuously for 15 days. And most peculiarity of the case is, my lord, if pilot will see the evidence of PW4, he has stated in the cross-examination at paragraph 4 that this Joki Pradhan, PW6, was very much present when the statement of PW5 was recorded. Madam, we kindly see evidence of PW4 at page 151. Paragraph 5, continuation. Madam, page 3 or page 151. जोगीनाथ प्रधान, जोगी प्रधान, काशीनाथ प्रधान, हरि नायक, हलुरी बेहरा, ब्रजबंधु कर, फकीर कर, बामन विश्वाल PW2, Sarath Pradhan and many others were present when the police reduced into writing the statement of Prafulla Kara.
Who is Prafulla Kara?
Prafulla Kara is
The
PW5
Informant.
informant,
Who was examined on?
who was examined on very day on 28/6/91.
মানে ঘটনা দিন তা পরদিন
ঘটনা দিন 9:30 রে এফআইআর है ना 9 investigating officer says when reaching a-
ଗାଁକୁ ଆସିଲା ପରେ ତାକୁ ଏକ୍ସାମିନ ମୁଁ କଲି
another peculiarity of the case is, my lord, if my lord will see the evidence of this PW4, why I am harping on PW4 is, my lord, PW4 is the person who had informed the police at the very first instance at police station about the death of Bhagirathi Kara. Instead of, my lord, recording, lodging the information that they made, though it's a cognizable case, and when he is mentioning that I have heard that Bhagirathi Kara has been murdered. So instead of lodging the same as a first information report, an entry was made and police came along with PW4 to the village. The PW9 came to the village along with PW4. And paragraph 5, why don't we kindly see page 150, paragraph 5 of the cross examination. Soon after the police reached in my village, inquired Prafulla Kara. Let me kindly take note of it. How he could know that Prafulla Kara was the person who has seen the occurrence. Beforehand, nothing was there before PW9 to ascertain who are the witnesses to the occurrence and who are the assailants. Nothing was there. Soon after the police reached in my village, inquired Prafulla Kara. I only accompanied the police to my village from PS. I had not stated the police the name of Prafulla Kara. PW2, Bhagavat Pradhan, PW3, Baman Biswal, PW2, Bhagavat Pradhan, PW3, and many others, and thereafter sent for Prafulla Kara. And neither PW2 has stated anything that any inquiry has been made by PW9 from him, or PW3 has stated in that respect. And many others, but they have not seen the light of the day. Prosecution has not examined any of them. From whom PW9 asserted that PW5 has seen the occurrence and he is to be the informant. My lord, another peculiarity of the case is, police sent Gramarakhi Shukuru Nayak, whose house is nearer to the place of occurrence. But that Shukuru Nayak has also been withheld from prosecution box to be examined during trial. He's the Gramarakhi of the village. And in the same paragraph, this witness has stated, Jogi Pradhan, Kasinath Pradhan, Hari Nayak, Haluri Behera, Prajabandhu Kara, Hakira Kara, Baman Biswal. None of them have been examined except Baman Biswal, and that as examined as PW2, and Bhagavat Pradhan, I think, well at 3. They have been examined as seizure witness, nothing there. And Another thing, my lord, which comes to the mind, because my lord, I'm arguing a case, and my lord is deciding a case where 12 persons have been convicted for the offence under section 302, and they have been sentenced to undergo life for life. My lord, case of prosecution, the prosecution is to prove this case because we have not taken any plea of alibi or any sort of exceptions available. So they have to prove the case beyond all reasonable doubt. These three witnesses have been introduced as witnesses to the occurrence. My lord, may kindly see. This PW5, if my lord will see the evidence of PW5 also, he has been projected as a witness to the occurrence, and he is the informant in the case. While a person who has seen the occurrence, a ghastly murder, and that to deceased, his agnatic nephew, that is the prosecution case, his agnatic nephew, he has seen the occurrence. When the question has been put to him that what has happened after the assault to the deceased, he said, I do not know. Who has taken him to the hospital, that I do not know. Is it the common attitude, my lord, from past experience must have seen, my lord, a relation has been killed, assaulted brutally by 12 persons. They say indiscriminately assaulted. But he left the deceased or the injured at the spot and will come and rest in his house. He said, I have not gone to the police. A person who had gone to the hospital along with the deceased is the father of the deceased. And he says, till date, I do not know where the occurrence has taken place and who has assaulted my son. And another important aspect, my lord, I'm quite conscious about the position of law and the importance of this, my lord, that, my lord, PW1 and 5 and PW4, these three witnesses were examined immediately after the occurrence when the police reached at this place. That is on 28/6/91 at around 9:45 p.m. Inquest was done on 29/6/91 at 7 a.m. I'm quite conscious about the fact, the position, the penalty section 174 CRPC, which deals with inquest. It's not that important pertaining to the name, mentioning the name of the accused, this, that, well. But here is a case, Exhibit 9, the first information report, because in the inquest report, it has been mentioned, the article PS case number so and so. And signatory to the inquest report, a PW4, yes, PW4, and the investigating officer himself. And this PW4, my lord, if my lord will see the evidence of PW4, he has stated in paragraph 3 that in the village, the police inquired into the matters and Prafulla Kumar Kara narrated the incident to the police. The latter reduced into writing his information and thereafter read over and contents of it to him and took his signature thereon. They also took my signature on that report. I signed on each paper of that report. This is FIR marked as Exhibit 9, and my signatures are 9/1, 9/2, 9/3, and 9/4. So he is a signatory to the FIR, and he was very much present at the place of inquest and also signed the inquest report. This investigating officer who has recorded Exhibit 9 on the oral version of PW5, he is also a signatory to the inquest report. Can it be ignored, my lord? Is it an empty formality, my lord? Or, my lord, it can be presumed that this affair was not prepared by the time this inquest was valid. Even the dead body challenge most peculiarity is the dead body challenge, my lord, is also blank with regards to the involvement of the accused persons or any about the occurrence. That is also blank. That has been specifically admitted by the investigating officer in paragraph 17 of his deposition, my lord. The fact that, my lord, this and in some cases, Honorable Apex Court has been pleased to observe when the affair has been lost and these eyewitnesses have been surfaced to the picture, they have been already examined. It is but natural that there should be the party to the inquest. There should be there should come before while the inquest is being done. Here, my lord, they have not this to PW1 or 5 or 6. They have not been examined or they have not signatory to the inquest report. But PW4, who is a signatory to this affair, and investigating officer as well as PW1, PW4, they say PW5 has not given a written affair. He has given an oral report which has been reduced to writing. And the oral report, as per the investigating officer, by good many persons who are present, they are at the spot and they have heard it. When the names of the accused persons were there before the investigating officer, can it be blankly written in the Procedural? Can it not be presumed that these accused persons have been implicated later on and so because in between 2-3 days have been passed? Because our affair was lost on 28/6/91 and it has reached in the court of law and magistrate on 1/7. And 1/7, the time has not been mentioned. I was verifying from this copy. Time has not been mentioned at what time the investigating officer has received it. I was also going through a judgment ballot of the Apex Court where it has been held that in the case of 302, where when the allegation of murder is there, it's a serious offense and magistrate is to mention the time also, date and time. My lord must have seen the judgment of Mehraj Singh and Thanedar Singh. In that aspect, Honorable Apex Court has been pleased to observe that the affair was at the embryo stage and that has been filled up later on to implicate the innocent persons. That has, number of judgments are there in that respect. But I'm not submitting, my lord, that for that reason prosecution case is to be thrown out. But the fact that the conduct of PW5 is so tainted, it cannot inspire confidence, my lord, to fill up the guidelines fixed up by the Apex Court in 57 Supreme Court 637. Maybe true, must be true, and that too reliable or unreliable and partly reliable but partly unreliable. And suggestion has been put to PW5 to the effect that 10 to 15 days before the occurrence, the daughter of his brother, Tirnath, who has not been examined, was kidnapped by the deceased, who is his cousin brother, my lord. But it could not be substantiated through any document, as because in some cases, my lord, considering the humiliation in the public, family members, they do not come to the police station, but they decide their own course of action. And accordingly, suggestion has been given that some hired guddas have been procured and the occurrence has taken place. This, my lord, can be visualized with suspicion on the face of the evidence of PW7, who is none other than the father of the deceased, who was stated categorically that till today, my lord, the last occasion was pleased to observe, occurrence of 6-7 years. Till today, I do not know where the occurrence has taken place and who has assaulted my son. The other brother, Rajabandhu, he has been withheld from the prosecution, but though he was very much present during inquest, he has not been examined by the prosecution. I am not submitting, but the each and every witnesses, those who are available around, this will be examined. But law is very clear. The prosecution should come forward with the witnesses whose examination would have unfolded the narratives. But beginning from 71, Supreme Court 1586, paragraph 15, till today, my lord has also observed in good many cases in that respect. And law is also clear that evidence is to be weighed, not counted. Here, my lord, if this, at least this Sukuru, who had been deputed by PW9 to go to the house of this Procedural CORAM, he should have been examined because he is a Gramaraki. He is not a common citizen. He is not interested for prosecution. He is not interested for defense. Why he has been with her? And my lord, the case diary, it has been also brought in the cross-examination of PW9. His name finds place in the very first date of the investigation in the case diary. Well, there are some cases where the witnesses have decided to implicate innocent persons. They will come forward. Whatever may be the situation, they will implicate. If they want to implicate A, B, C, D, E, they will implicate. What is to see under what circumstances they have been examined and what they have stated, considering the surrounding things, my lord.
Just a
We can.
Case where there are eyewitnesses and otherwise the evidence of the eyewitnesses have not been settled. If the inquest report and dead body challan does not indicate the name of the accused person, then that would be a ground to discard the evidence of the eyewitnesses. That is your contention.
There are some judgments in that light, but there are some judgments.
Alright, you find that those judgments.
Inside. My lord, here also, my lord, another.
And so you are aware that who are those two persons who have signed the inquest report?
My lord.
One of them have not been examined, the other has no personal knowledge about the names of the accused person.
PW4,
He had no knowledge.
he had no knowledge, but he was a party to the affair, and he is a signatory to the affair. My lord.
All right, that column has been filled up by Brajabandhu Karo, who has not been examined.
Yes. And my lord, this witness, PW4, my lord, each page he has signed in the affair, and in PW9, who is the investigating officer, he is also signatory in the inquest report. My lord, can the investigating officer is ignorant about the affair? Can it be presumed?
No, let us say there is that it has been not omitted. Question is that what would be in the legal side, what would be its implication that if it is not omitted and you are unable to dislodge the evidence of the eyewitnesses, can on the sole basis, maybe that it is let us say, go to the extent that some kind of omission or on the part of the investigating officer.
First thing,
He had
whether it
some
can be
latches.
taken to be an omission.
Let us say it has got some latches on his part, or we can extend to that it is a perfunctory investigation. Let us go to that extent.
Madam.
So on that basis, whether the evidence of the eyewitnesses can be.
But at this juncture, I want to say that I should be fair enough to submit before my lord. I don't know whether government advocate is aware of this decision or not. And this Thanedaar Singh and Meher Singh, and later on a division bench of Calcutta High Court, well, my lord, in case of 2011 Criminal Law Journal 1677, then Chief Justice Honorable Justice Patel and Asim Kumar Roy, they have also relied upon this judgment and they have reached at a conclusion. In this way, it is therefore beyond our, I am reading this that relevant.
Yes, sir, please.
Now coming back to the case in hand, we find PW 13, Shankar Rai Chaudhary, was the officer in charge of Lalgola police station. And at that relevant time and upon receipt of the complaint from PW 5, Indaul Haq recorded the affair of the case and took up the investigation of the case by himself. The affair was marked as Exhibit 5 during the trial. In the said affair, the name of the appellants and the manner of their individual participation in the commission of the offence has been specifically mentioned. Admittedly, the said police officer PW 13, Shankar Rai Chaudhary, held the inquest report at the time of inquest. Held the inquest report, and at the time of inquest, PW 5, Imdaul Haq, the informant and an eyewitness to the occurrence, was very much present. It is therefore beyond our comprehension when before holding the inquest, the affair was lost by an eyewitness to the occurrence, and in the said affair, the assailants have been categorically named. Then in that case, as to why in the inquest report only it was noted that the victim was assaulted by some miscreants. Mere non-mentioning of the name of the assailants in the inquest report is one thing, but when before inquest the name of the assailants has been transpired and they are named in the affair, non-disclosure of their identities in the inquest is another thing. In other words, although it is not the law that the inquest report must contain the name of the assailants, but when before holding of the inquest, the identity of the assailants were surfaced, a note in the inquest report that the assailants are unknown miscreants, in our opinion, partly casts a doubt as to the reliability of prosecution case.
You see, Mr. Dhar, in that column number 9 of the inquest report, it is mentioned that opinion of the witnesses to the cause of death. And that has been filled up by one person whose name is Brajabandhu Kaur.
Brajabandhu Kaur is a reported witness.
Right, he has not been examined. So he has mentioned that more bhai ko Durbutanko Dwara Honai Marai Jai. That's all. So Brajabandhu Kaur is not coming to the picture. Prosecution has, you have also not examined. And another person.
How can a witness from their side?
No.
Because it is there in the prosecution case. All the witnesses except the official witnesses belongs to one side and the accused person belongs to other side.
If you think that this thing you are to take an advantage of it, then you should have brought him to the witness box. There is no problem in that. Is it your contention that a witness whose name is mentioned in the charge sheet and not examined by the prosecution cannot be examined by the defense?
No, I'm not on that.
So according to you, Brajabandhu Kaur
he happens to be the brother of the deceased.
Brajabandhu Kaur would have supported your case that he had the knowledge, everybody had the knowledge. In spite of that, he mentioned, and he could have.
Rather, his father has been examined and said, I do not know where the occurrence has taken place and who were the assailants. But his PW7 has 7 sons. 5 sons, my lord. This Prajabandhu Kora is one amongst them. Father who has carried the injured to the hospital alone.
Who has carried?
No, no.
No.
Father was
He was in PM.
He was
No.
He was
Let me see evidence of P 7.
P 7 has carried the PM post-mortem, not the dead body.
Father was living.
Not dead body, my lord. The injured.
No. It is not there.
He was living in Bhubaneswar. After getting information, he was
He came from Bhubaneswar. By then, he was already taken to hospital and he.
there.
Nobody, it is not neither the prosecution case nor even you have brought anything from the mouth of any of the witnesses that the Brajabandhu Kora had any knowledge about the commission of murder by these accused persons.
But this
ତେଣୁ
Sudhana,
ସିଏ ତାର ମେନସନ କଲା ଯେ ମୋର ଭାଇକୁ ଦୁର୍ବୃତ୍ତଙ୍କ ଦ୍ୱାରା ହଣେଇ ମରା ହେଇଛି ସୋ ଏବଂ ତା ଦେହରେ ଆଉ ଜଣେ ସାଇନ କରିଛି ଉଦୟକର ଏସାଇଡ୍ ରେ ଯାହାର ମଧ୍ୟ ପର୍ସନାଲ ନଲେଜ ଅଛି ଯାହାର ରିପୋର୍ଟରେ ଷ୍ଟେସନ ଡାଏରୀ ଏଣ୍ଟ୍ରିଟା ହେଇଛି କାରଣ ସିଏ ଏଭିଡେନ୍ସ ଦେଖିଲେ ସିଏ ବାଟରୁ ଆସୁଥିଲା ବାଟରୁ କୋଉଟା ଶୁଣିଲା ତେଣୁ ସିଏ ପଳେଇଲା ସେଠୁ ପୋଲିସ ଷ୍ଟେସନ ହି ହାଜ ଅଲସୋ ନଟ୍
but he is a signatory to the FIR, my lord.
no FIR ତ ଆସିଲା
Brajabandhu.
Nahi, Udayan.
ଉଦୟନାଥ କର ପରେ
His signatures have been exhibited
No.
in each page he has signed
In the FIR.
in the FIR.
it's all right.
He was quite, because FIR is prior to this inquest, my lord.
So the very purpose, as we have already submitted on that, the very purpose of 174 Evidence Act is what is the objective that we have to see. So merely because the witness, had the witness given the name Brajabandhu, suppose, what would have been your argument? That he was not the person present, he heard the name and has given. So he is giving a
No.
definite
What
answer
would have
to
been
it.
the argument? What
No,
would
no,
be the argument?
no. What would have been your argument? I place this argument to myself.
My lord.
What would have been our argument then? He is not a person present in the scene of occurrence, and he has heard the name. And if he is giving a true fact that he doesn't know, but he is giving that some excellent, sir. So how can it be taken as a
Why I am
worthy
saying-
one?
Why I am submitting so, my lord? Here the occurrence has taken place on 28/6. Inquest was done on
Very nice day, morning.
29/6, 7 a.m.
Very next morning, yeah.
Next day morning at 7 a.m. Time is there, my lord, exhibit 13, 7 a.m. In between, my lord, on 29 was Saturday, but I was verifying from the calendar. 28 was Friday and 29 was Saturday. FIR would have been sent, my lord, to the police station. That has not been done. On 30th, it has not been done. At 1:07, it has been sent, but time has not been mentioned. That has also been deprecated by the Honorable Apex Court.
Have you put a question to the IO in that respect?
IO has not stated, my lord. I have also verified
Have you?
that my lord may put me this question. It is prosecution is to come forward.
No.
My lord may see PW9. No, though he has categorically stated that when he received the FIR, what he has done, he has not stated a single word that I was busy in my investigation for which I could not. They could have given that explanation.
How did you say that he dispatched it not on 29th as shown in the FIR, but on 1st, and therefore he had got ample time to.
My lord, if prosecution would have said something, we would have put questions in that aspect.
That is a documentary evidence that is available on the face of it in the FIR, that when the document was, that's official document prepared,
My
and
lord.
you are not putting any question to the IO that and disputing that he had. Have you put any question? If you would have put any question, and that it was, though you have shown that it was dispatched from your police station on 29th, but it was not dispatched on that day. It was dispatched on 1st, and that is how it reached the magistrate on that day. No such question has been put. So opportunity must have been given that
Now comes up, my lord, whether prosecution is to say this or defense is to say this.
Unless that's
My lord, that
you
answer
have
has
to,
been
you have
given.
to put question to that, was to give an explanation that And whether that we said on that day, whether that explanation would be acceptable, we cannot presume on the basis of some decision somewhere when the official documents and
But
what is 114.
Here is a case,
It is-
madam. Madam, 2003 SCC
You
criminal.
don't go to
No,
the
no, that
decision.
is the
No, but
principle.
here is-
Decision.
That
Why,
is the
why,
principle.
You
why
are
I am
always-
submitting,
you are
madam,
always-
why I am submitting
In
when
every second sentence, you are going to a decision. Come to the factual.
have
as to-
actually, madam,
See the
actually
evidence.
on.
Why are you going to the decision?
Wow.
Decisions are this side, that side.
Madam,
If you
criminal
give
cases,
us 5 decisions on a particular point, we can give you 10 decisions.
See, we are not on that because if we start giving, again, this will be protracted. So better that you give, we will see. And then whatever decision you have shown in 2011 has also been contradicted
It has been-
on many occasions. So we are not on that. We do not want to enter into that.
Also not
We-
that, madam.
From the very first point of time, we are putting you a question that if we are not finding any material that this evidence of these 3 eyewitnesses on the face of it is to be disbelieved. Question is that if the names of the accused persons are not there in the FIR, in the inquest report or the dead body challan, can it be a ground to disbelieve the evidence of the eyewitness? Just pinpointedly answer it to the
Right.
factual. Don't go to the law. Law, there are so many decisions, this side, that side, and those are considered.
No, madam, I should
factual
not submit
scenario.
that, they will be disbelieved in that. I can say they were not examined earlier in point of time. They have been subsequently examined. I
You
should
see,
not.
suppose one of the eyewitness would have filled up that column, right?
Madam.
And in that column, it would have been mentioned that Moro Amakoku ke Madijati. Hala? Amok ke Madijati. So it presumes that by that time that inquest report prepared, this man who claims to be an eyewitness had no knowledge. It is not a case of that nature.
I know.
It's a case where 2 persons who are, one person has not been examined, the other person had got no personal knowledge, and they are the person whose opinions have been taken while filling up the column.
Madam, this argument of mine, madam, I am not the opinion, madam, this inquest report, because it has, the column has not been filled up, they will be disbelieved. My entire endeavor is that they were not examined the way it has been stated. Not only.
That is why it is stated that opinion of the witnesses, they would have analysis କରାଯାଇଛି ସେମାନଙ୍କର ମତରେ ୟାର ଡେଥ୍ ଟା କେମିତି ହେଲା, ମାନେ କୋଉଠି କଣା
Apparent
ହେଇକି
cause of
ମରା
death.
ହେଲା ନା ସୁଇସାଇଡ କରି ମଲା ନା ପାଣିରେ ବୁଡିକିନି ମଲା, ତାଙ୍କର opinion ଟା
Yes, Mr. Dhara, you will also agree with that. The very objective of 174 is to find out the apparent cause of death in an unnatural death. That is the whole. So, any kind of discrepancy we find or informative in find.
On that, madam, this is one of the point, madam.
Correct.
Why I am saying so? Here, madam, if madam will see the spot of occurrence, because this submission of mine has been taken note of in 2011 Supreme Court, where this Mehraj Singh and the Tharidhar Singh has been discarded. So my I am quite conscious about that. But my endeavor is to draw Myler's attention that as because these 2 days gap we are getting, when at 29 and 30, their evidence might have been subsequently recorded. Sorry, their statements might subsequently recorded, and it was not there earlier. That is my entire endeavor. Not that whether this inquest report is the basis 174 is the drop. That has been denied by Apex Court.
Mr. Dhar, the way in this case would have been for the defense that if authentic information comes from some sources that in fact the FIR was not dispatched, they got from it that from that what they call police port, that it was not received and there is no entry on 29 that it has been received on that day. These petitions would have been filed to call for that register to show that in fact there is no, this should have been done by the defense counsel, but the defense counsel is very sure that it has been received on 29, but it was placed and it was a neglect on the part of the dealing assistant.
For that, no question has been.
So That should have been done. So you don't think that when a legend is coming, cross-examining, he is not aware. But deliberately, he must have asked to verify that record when that FIR was received, and you must be sure that it was received on 29. That is why it has left as such.
Malad.
Right?
And Malad, another thing which is also important, Malad, but has got important bearing about the place of occurrence, which can be taken to be which place can be taken to be the place of occurrence. Because on a reading of the evidence, Malad, it will be seen that some total Malad I've just prepared a topography, Malad. Distance between Saranpur police station and village Sangarada is about 10 kilometers. Connected by a pitch road which passes through the entire village Sangarada, that is Purnasai, Nuasai, and that pitch road connects the village Godipada. That is the statement of PW 9, para 20, first 4 sentences. So village Sangarada consists of 4 sahis, namely Purnasai, Nuasai, Totasai, and Billa Goroda Sahi. And other 3 sahis are Totasai and other 3 sahis are intervened by river Kusumi. The house of Bhagirathi is situated in Totasai. If one comes from Saranpur to Sangarada, first he would pass through Purnasai and then he would come to Nuasai. All these accused persons belongs to Nuasai and all the witnesses except official witnesses are of Purnasai. The house of accused Ladukara situates at a distance of 300 to 400 cubits from the south of Subad towards Godipada, and there is a road leading to Totasai near the house of Ladukara, and by then the river bed Kusumi was having little water, and that was the shortest route to go to the house of Bhagirathi. Well, that is evidence of PW1 Parate. They have given that. And if Myler will see that I was stated and Myler has also answered it, that if Lordstein should have been there, then I would have mentioned the same. And well, a cycle has been seized from the house of Bhagirathi Kara, that is Totasai. Father of deceased had produced a cycle that is on 797 or something, minute. That is it. Good enough. Nine 791 minutes. And it has been said by that he says, I seized it on 9/7/91 from the house of Fakiragara, PW7. And Fakiragara has stated that you don't know who was giving it to me on 9/7. And with regards to the 2 cycles, one cycle has been seized, the other cycle they say from the well, but IO says I verified after recording the affair, it came to light that is the involvement of 2 cycles and their importance in the truth of the case. And in my spot visit, I had not seen either of the cycle at the spot or near about. There was a well by the side of the cabin of Subal Pradhan accused. I marked that well carefully, but did not find anything of any cycle inside it. had on investigation throughout the night on 28/6/91. I have examined Bhagavat Pradhan, son of Kaivalya Pradhan, PW3, at about 2:30 a.m. on 29/6/91. I seized the cycle on production of Fakira Kara, PW7. I seized it on 9/7/91. Exactly what is the place of occurrence, and if the place of assault will be taken to be the place of occurrence, nothing was there, because immediately after the information of PW4 before PW9, they reached in the village, but nothing was there. Who was lifted the cycle, and the articles which were there with the deceased, nothing was there. And place of occurrence, plus spot of occurrence or place of occurrence, but is doubtful from, from all corners, but similarly, my popular
Yes, Mr. Bhaul, any further argument?
Well, this with regards to PW6 and belated disclosure,
Yeah, we
and
have no-
how PW9 could know that PW6 has stated that he volunteered himself to be examined as a witness to the occurrence. And how PW9 could know this? This has been decided by our High Court, where Matter has decided, and that is in 2022 in the case of belated disclosure, and recently also when in case of 2025, it is decided by this honorable court also in that June part manner reported. PW6, he was also present when the affair was recorded, but he was not examined by the police. No clues, it's a fact that no cross-examination has been made in that respect also. But fact that he was present and that has been stated by PW4.
Have you put any question to PW6 that whether you voluntarily
No.
come to the IO to give your statement, or the IO got some knowledge that you are an eyewitness to the occurrence, that is why he came to you and recorded your statement? No question. Have you put any question to the IO that from which source you came to know that PW6 as an eyewitness to the occurrence?
No, that is
Then
not.
how can you advance the argument that from which source he got the knowledge and there is no material?
This
It should not, it should have at least indirectly some questions would have been put, that by the time you have examined this number of witnesses, from those statements, whether there is anything on record that PW6 as an eyewitness to the occurrence? No, matter ends there. Okay, stop there. And the question would have been put to PW6 that you have not volunteered to go to the police to give your statement. Stop there. Then you could have argued this matter.
PW9 has not stated, we have also not put it.
That is exactly the thing. Now you are saying that how he came to know.
Required for this purpose. And with regards to the injury sustained by the deceased, Bhagirathi, 12 in number, 60 in number, 12 accused persons, and it is stated that all of them have indiscriminately assaulted. And injuries, though, are simple in nature, but cumulative effect of the same caused the death. And the weapon of offense seized from the house of accused Worth, except the lathi ballot, nowhere broad stave was found. And injuries, as per the evidence of PW8, are mostly incised well. On back, at head, and left leg, all incised wound.
No, the weapons, those were used by the accused persons,
Mallet.
all those were sharp cutting weapons. So
Mallet.
obviously,
But
any weapon was anybody's hand like lathi or anything like that, because that is not the case.
No.
Everybody is
lathi blood আসছে আর কোথায় নেই
हाँ नहीं माने जो sharp cutting weapon रो injuries गुड़ाक सबू देखिছি ना
ଆଜ୍ଞା incised wound
incised wound गुड़ाक
ଆଜ୍ଞା
ଏବଂ ସମସ୍ତେ ହିଁ ଏତିକ ସାକ୍ଷୀ 3 ଜଣ ଯାକ ସାକ୍ଷୀ କହୁଛନ୍ତି ଯୋଉ weapons କଥା କହୁଛନ୍ତି, all those are also sharp cutting weapons.
How does that look? The weapon of offenses have been seized from the accused subordinate.
Arsa, Kati, out of Bhali.
Bhali,
These are all sharp cutting weapons.
Systematically punctured wood how?
ନାଇଁ
Inside.
ଖାଲିଟା ଅଛି ଗୋଟେ ପଙ୍କ୍ଚର ରୁଣ୍ଡ ଅଛି ଗୋଟେ ankle ରେ ଗୋଟେ
Busa, the manner of use it
that
depends.
depends, yes,
Suppose
that
ଆପଣ
again depends.
push karibe, then it would be a puncture wound. If you put it in this side, then it would cause incised wound or caught injury. So it depends
will
how.
bled from both
हाँ,
sides.
There was no punctured wood.
No,
All incised.
incised wound.
All
All
incised.
And the weapons which were also marked, that is Busa, Farsa, Kurhadi, Kottari, एगुड़ा सब mark ହେଇଛି MO ଏବଂ ये ମଧ୍ୟ जो PM doctor ମଧ୍ୟ କହିଛି police produced Kottari so before me and made a query if these injuries caused by on the person of the deceased, if possible by these weapons, I opined in positive. And that report has been marked as Exhibit 12, inquiry report. So, any further submission, Mr. Don?
My learned friend.
Yes, we definitely hear. Of course, Mr. Nayak and Mr. Panda is also there, and Mr. Mishra is there. They are for accused persons. So we'll definitely hear. We just want to know that whether you want to, at this instance, you may close here. You can supplement it after
I can supplement.
after the state council. You may also argue. Yes, Mr. Nayak.
I will submit a note. I will adopt the same because same set of evidence, my lord.
Now, any
Any
if
additional?
you additional thing, if you want to say, you can say,
I can.
or the written note of argument you may give with citation.
That is only after he replies, my lord.
Obviously. No. Okay. Now here then, where is Mr. Panda?
He's on his legs. He'll appraise the court after.
Okay, then we will hear Mr. Mishra and then the state council and ask him to come because thereafter we, yes, Mr. Mishra, please come.
No, I will not take your lordship time for repetition. So far, the legal aids of the respondent number 6,
Laduki, sir.
Lord Kishore. Your lordship has had almost
No, about this Ladu Kishore, what was the role in the FIR?
nothing. FIR there is nothing. The PW5 has not stated anything.
No, just go one by one.
No.
ଆପଣଙ୍କର Roll house is you throwing of bombs to?
That is also not specifically.
ନାଇଁ ନାଇଁ FIR ରେ ଆପଣଙ୍କର ନାଁ ଅଛି?
ନାଇଁ
So please come to that place.
ମ୍ୟାଡ଼ାମ
ଆପଣଙ୍କର ବମ୍ ଫୋପାଡ଼ିବାଟା ଅଛି 97 ପୃଷ୍ଠାର ଶେଷ 3-4 ଲାଇନରୁ ଆରମ୍ଭ ହେଇଛି। ପାଇଲେ ସେଟା
ମ୍ୟାଡ଼ାମ
FIR
ମ୍ୟାଡ଼ାମ
97 ପୃଷ୍ଠାର 4 ଲାଇନ ତଳୁ ଆରମ୍ଭ କରନ୍ତୁ।
ମ୍ୟାଡ଼ାମ
ମୁଁ ସାହି ଭିତରକୁ
ମୋ ସାହି ଭିତରୁ ଆସି ମୋ ସାହି ଲୋକଙ୍କୁ ନେଇ ଘଟଣାସ୍ଥଳକୁ ଯିବା ବାଟରେ ଅପୋଜ ପକ୍ଷ ତରଫରୁ ଆମ ଉପରକୁ ବୋମା ଫୋପାଡ଼ିବାର ଆମର ଜୀବନରେ ଚାଲିଯିବ ବୋଲି ଆଗକୁ ପାଣି ବିକଳରେ ଯାଇ ପାରିଲୁ ନାହିଁ। ଯେଉଁମାନେ ବୋମା ଫୋପାଡୁଥିଲେ ସେମାନଙ୍କ ଭିତରୁ କିଶୋର ପ୍ରଧାନ, ବିଧୁଭୂଷଣ ପଟ୍ଟନାୟକ, ହରିହର ପ୍ରଧାନ, ଅଭିମନ୍ୟୁ ପ୍ରଧାନ, ଗୋଲି ପ୍ରଧାନ ପ୍ରଭୃତି କୁ ଚିହ୍ନେ।
ତ ଆପଣଙ୍କର ନାଁ ହେଲା ଲଡୁ କିଶୋର କର।
ମ୍ୟାଡ଼ାମ
ଯଦି just let us take note of it. Lord Kishore is appellant number 6 in 47. So not named in FIR. Now you come to the name of, the statement of the informant, that is PW5. Has he named you to have thrown bombs?
No, ma'am.
Just
Your
come,
lordship
PW5 please come. PW5 who is informant to? Say portion को पढ़े आसो।
ମ୍ୟାଡ଼ାମ ଫାଇଭଟା ବୋଧେ କହିছে ସେ ୱାନ୍ଟା କହିନି।
नहीं
ମ୍ୟାଡ଼ାମ ଆଇ ଏମ୍ କମିଂ।
please come. एक bomb पकिया कथा। अपन come to the paragraph 5 page होशी 153.
I found the incident.
I informed the incident.
I informed the incident in my Sahi, and so many persons of the Sahi came to the spot. But the accused persons threw bomb at them, and so they could not reach the spot. Accused Goli Pradhan, Vidhubhushan Patnaik, Abhimanyu Pradhan, and
Harihar and Kishore.
Harihar and Kishore.
Few bombs. So Ladu Kishore name is also
No, also not.
just. Now you come to PW6.
Madam.
ସେଇ ପାର୍ଟଟା କୁ ଆସନ୍ତୁ।
Paragraph
ବମ୍
3.
ବମ୍ ପକେଇବା କଥା। ହଁ ପଢ।
While so running, accused Kishore Pradhan and Abhi Pradhan, Ladu Kishore Kara, Madhu Pradhan obstructed him from his front side.
This is not the role so far as the other eyewitnesses are concerned.
Yes.
Here, Ladu Kishore has been given a role that he
Obstructed.
which is not
Yes.
stated by the witnesses
PW5.
like PW5.
Right.
Now, bomb পড়ে আসুন। The last 4-5 lines. Say page ro.
Same page 3 lines.
While so running, accused Kishore Pradhan and Abhi, Ladu Kishore, Madhu obstructed, then come down to that.
ତାପରେ ପଳେଇ ଆସନ୍ତୁ।
Accused.
Some of the accused persons threw bombs at them.
ସେଇଠି ପଳେଇ ଆସନ୍ତୁ।
Some of the accused persons threw bomb at the accused Vidhu Patnaik, the Kishore Pradhan, Goli Pradhan, Harihar Pradhan threw bombs at them. Hari Pradhan threw the cycle of the Bhagirathi Kaur in a well.
So PW6 ମଧ୍ୟ ବମ୍ ପକେଇବାରେ ଆପଣଙ୍କୁ implicate କରୁଛି। Now the last eyewitness is that is PW1. PW1 ର ପଳେଇ ଆସନ୍ତୁ। ସେ ବମ୍ ପକେଇବାଟା କୋଉଠି ଅଛି କୋଉ ଫେଜରେ?
bomb ପକେଇବାଟା ବୋଧେ କହିନି।
Has he stated anything about the bomb?
ନାଇଁ bomb PW1 ଟା ବୋଧେ bomb ଟା କହିନି, but my learned friend was on that day he was submitting. I mean, he was placing that evidence.
Paragraph 3 ରେ ଏଇ ଯୋଉ ଫାର୍ସା assault ସରିଗଲା। On this I ran away to my sari.
Sorry.
ତାପରେ ପୋଲିସ ଆସିଗଲା।
No, no, he
They
has
have
not
not stated
stated
about
about the.
bomb, acha. So PW1 has not stated to have seen throwing of bombs by anyone.
Yeah. And above all, my lord, what I was hearing from my learned friend Mr. Dholo, what we are submitting, the entire prosecution case, the genesis of the prosecution is a very concocted one.
Hmm.
From the entire facts he was submitting on that, I was there up to launch.
Hmm.
Of course, I was not there up till now.
No, it's correct.
From the till now, till that time, what you were submitted and what your lordship also by question further elicited. The entire prosecution, the genesis is a thoroughly a concocted case. A person has died, but subsequently the how he has died, it has been all been manufactured. By showing the recovery, not recovery, recovery of cycle after some days in a place where somebody has not stated and contradictory evidence. The entire episode, the prosecution shows that the prosecution has not approached the court with a clean hand. Nothing. So when the genesis of the prosecution case goes, the rest all other goes well. The cryptic statement of the witnesses. Suppose somebody has said that see he assaulted, he assaulted, he assaulted. But the whole story of the prosecution case is the concocted one. And what I gather from the detailed argument advanced by Mr. Dholo, and your lordship has also put certain question in support of that almost that thing, but not concluded that it's a concocted one. Because the way cycle was recovered, there is no explanation, there is no effort. If the prosecution says in this manner it has happened, then it was duty bound to the prosecution to find out the trail of everything. And they must record it, they must bring it to the record. If the genesis of the prosecution case goes, then
you are appearing for only that accused
yes,
or the
no,
other?
no, it's by the way, I'm only one.
No.
Legally asking.
Because in that 47,
There are
the
others also.
surviving accused persons are appellant number 1, Goli, then appellant number 4, Kishore. That's all. These two are, apart from your legal heirs, these two are surviving. Who is appearing for this in 47?
You.
Mr. Dhar, 47 ne ki appear korchen?
Mr. Nayak.
You are
Consent.
okay, Mr. Then we'll.
It appears that is a more or less like followed the what it happens in the district of Punjab. So they implicate a large number of people they can. Here also it appears, subject to your lordship scrutiny, that a person has died and it is because of the some hostility or some sort of enmity between the parties. They have implicated as many persons as possible. And the IO has not mechanically has as usual, because the investigation your lordship knows is virtually a mockery in our system, and it has become still reducing. What I say, of course, what I say is your lordship seeing more. Is the standard of investigation is going on down and down. So here in this case, the prosecution case, to find out whether the prosecution case is true or not, there is absolutely no effort. What I gather from the argument of my learned friend. And he was placing the material. Not only the contradictions, but also the non-availability of all the materials which your lordship said that suppose it is chained, that cannot be available. So at least they would have got the bag. If it was informed soon after the occurrence, naturally if somebody has taken everything, then who has taken it? Why he has taken it? For what purpose? Why he did not give it to the police immediately on his arrival? So there are many questions to be answered. So the investigation is almost a mechanical one, just to implicate mechanically and let court the course jaha karo. And to the ill luck, the judgment is also mechanical without a proper scrutiny. And particularly the person is a teacher, probably I don't know for what enmity they have implicated.
Who is the teacher?
Ladu Kishore, he was a teacher in the ME school. UG ME school. So I will say that there is absolutely nil evidence.
Anything has been
legal
brought up, Mr. anything has been brought out in that respect that he is a teacher from any evidence, or you are filing any document to that effect?
No, I was told by the legal heirs of the
No, because
legal heirs of the
except your submission, if somebody has stated that he's a teacher, it's all right in the
no,
evidence.
that I have not verified, but the legal heirs they have said to me at the time of
There must
substitution.
have been some document, just file it, there is no problem.
No, I can file it.
Authentic the salary, document. Can file it by way of an affidavit also.
Which statement of
No,
Just that he was a teacher, just that's all, because
a
you,
true statement is that?
they are impeded, because maybe some dues are still outstanding and they are not receiving that.
No, it is there. That is why they have
That is-
they have approached
exactly.
the honorable court.
So for that, have you in that petition, which you filed, mentioned that he is a teacher? And
But I remember, and I have also
we have allowed it.
I have also discussed.
No, we have allowed it, that petition day
Hmm.
before yesterday. We just want to know that.
Now, I will,
Yes.
if your lordship say, I will get the
Just
his
give-
service book and etc.
Hmm.
I inquired you 2 days back on that is Monday, your lord, when the case was posted. Whether he was a teacher in the high school or ME school, they said that no, he was a teacher in the UGME school.
Hmm.
I will produce the document now.
This occurrence took place on a school day, or it was
School day, Friday.
But in the
but in the evening, of course, in the evening. Please check it off. We are hearing the state council.
Madam, I am checking.
Yes, please.
Oh, you got it?
And please tell us. Before accepting to this stance given by the council for the appellant is both the appeals. The appeals giving are good by the legendary of this soil, and now be defended by the three junior stalwarts. Then I am there to support your lordship from your bedside. Here is the case depended by the based on the three eyewitnesses,
Hmm.
1, 5, and 6.
Yes.
And while examining all the witnesses of 1, 5, and 6 coupled with the statement of medical medical evidences, the learned trial court has taken a serious pain with persistent preservance, has discussed everything in the judgment, how the things has been done, manner in which in order to bring the charge against the accused persons. The entire episode of the story from the place of occurrence to and everything has been now disputed at this stage. Now there is no such occurrence. But nobody is advancing that whether death has been occurred or not. No defense has been advanced whether death has been occurred due to some other reason or grounds, not for this cause, which has been advanced by the prosecution story.
Hmm.
Here is the affair was lost in the very day. Now the affair is not being disputed that there is no such affair on that. If the affair would have been lost either in 1 day, 2 day, or in 10 to 12 hours delay, some suspicion may have been arised in the mind of the defense or somebody else that the false implications.
Hmm.
But here is the background that there was an enmity between the parties. There are two groups. One is led by the deceased Bhagirathi, another is led by the Kishore in other groups. So enmity between the parties cannot be ruled out, is not being ruled out because it is a constant evidence.
Hmm.
So enmity is sometimes it was reconciled and it has been in presence of the police. When the things has been reconciled being alleged in presence of the police and the occurrence is placed after few days, that does not mean that the enmity is completely obliviate from the mind of the persons who has been suffered from the person who has now been dead. What is the cause and reason that he was leading a person which is group who was opposed to the now the assailants who are the appellants here. So the reason behind the cause of death because the person was opposing to the present appellants in both the appeals. So when both sides are in tussles with each other, So it is a very good thing. Then it is being advanced. There was a good relationship and talking terms.
Yes, that is certificate.
The talking term does not mean that everything has been wiped out from the mind and the friendship became very cordial and very amicable. Here is the case. It is a very good ground to create a friendship with others, to take a revenge in somehow others by taking advantage of the time. That is the situation here when a person was coming from the market with the help of his cycle along with the other two eyewitnesses. And while he is proceeding through the road where the place of occurrence Subal Pradhan, the shop in front of which the occurrence has been placed, that one of the informant as well as the both are eyewitness to the occurrence. There, all on sudden, the Ranko Pradhan started a fast blow.
No, they were going ahead.
Followed by.
Followed by deceased. Not followed by the
The other two witnesses were ahead
right.
and the deceased was followed.
Yes.
By that time, by hearing some sound, what happened, the PW was seeing the occurrence and got down from the cycle carrier, which was he was a pillion rider there. In that case, all on sudden, one first attack made, the consistent evidence that he started to flee away from this cause by throwing his cycle. But what happened? He was obstructed by the appellants who are in the 47. If the person would have been escaped from this spot without any obstruction.
No. Obstructed by whom?
Appellants of 47.
Who has stated, sir?
This statement?
No.
They are obstructed by 2 to 3 persons. They are after evidence came.
We are telling you that the FIR is it there?
FIR is not is there. 2 to 3
FIR is not there.
FIR is.
Once you go to the 47, then we have to put some question to you. But see that whether any of the persons in 47 has obstructed the deceased when he was assaulted first by Ronco from the back and he was trying to escape.
Yes.
So is it there in the FIR anything?
FIR I'm just page
Go
97.
one by one. So just make factual aspect is in the Bulbal.
Page 97 make them clear.
देखियो
96 last part.
96 रो को माने अटकेई लेता ये तो कहउछंदी पढंतु आपण
भागीरथी आहत अवस्था 6th लाइन फ्रॉम द टॉप साइकेल तळे पकाई जीवन विकल रे दौड़ीबाकू आरंभ कला आमे दुहे जीवन विकल रे दौड़ीबा आरंभ करंते गाँ रो 2-3 जन लोक दैट मीन मार 2-3 जन लोक भागीरथी को जगी देबारे से आगो को जाई पारला नै जे माने जगिले सेमानक नाम कहि पारि नै चिनि पारिबे परे रंकंक फारसा द्वारा भागीरथी पीछा करी तार बाम पट गाल पट को फारसा द्वारा हाणी देबारे ताम बाम पट अधा छिड़ी जाई अति जोर रे रक्तस्राव होला भागीरथी मारानस्त द्वारा हाथ होई रक्तस्राव पड़ले ए सुजोग रे काळू और दुर्योधन दैट इज
आमे बर्तन सेही गोटे पॉइंट पई एफआईआर को आसुछु आपण रेज करले जे
ताकू जगी देले
बेली तो एफआईआर रे आपण तो देखि
आई एम प्रूटिंग दैट ड्रोन नेम इज नॉट देयर बट 2 to 3%
just one by one.
Yes.
So about obstruction to the deceased after the first blow. Hello? No names has been
No
mentioned.
name. 2 to 3%.
No names have been no names have been given. Okay, in the
So
FIR.
FIR being not encyclopedia, yes, the information. Then you'll also next place.
You are mentioning so many things. How many pages the FIR runs?
FIR pages 4-5 pages.
So you have given all the details right from the beginning.
Yes.
And this is an important aspect. You will not indicate that. And you will say that FIR not an encyclopedia. किसी लिखे नहीं?
And I'm coming to
नहीं गोटे page
the situation.
You are mentioning all the detail. So
then you're 97.
Yes, come to the PW5 evidence.
And 97, I play for 97. How the other obstruction being
Please
created?
come to the evidence of PW5. We are on a particular point. You are advancing an argument that these persons who are the appellants in 47, they have been assigned a particular role. Even at the very first instance, when the deceased was trying to escape, they obstructed him. So that would show that they were
Yeah.
having common intention. So please show us FIR. You have seen that ମୁଁ କହିପାରିବିନି ଦୁଇ ତିନି ଜଣ ଲୋକ. Now you come to the evidence of PW5.
The ଦୁଇ ତିନି ଜଣ ଲୋକ also named in the page 98, ଯୋଉ ବମ୍ ପକେଇଲେ.
ଓହୋ କଣ ଆମେ
ନା, ନା.
ଆମେ ବମ୍ ପକେଇବାକୁ ଯାଇ ଗଲୁଣି ଆମେ ପୁରା ଅଟୁ ବର୍ତ୍ତମାନ
Obstruction, my submission is obstruction in two ways. Either obstruction physically or obstruction by your throwing bomb, some that can also obstruction. So that they cannot proceed ahead.
ଆମେ ବର୍ତ୍ତମାନ ଡିସ୍କସନ ଟା ଏଠି କଣ ହଉଛି ଆପଣ ଆର୍ଗୁମେଣ୍ଟ ବର୍ତ୍ତମାନ କଣ ଆଡଭାନ୍ସ କଲେ ଯେ ସେମାନେ ଯେତେବେଳେ ପ୍ରଥମ ବ୍ଲୋ ହେଲା ସେ ଡିସିଜ ପଳେଇବାକୁ ଚାହୁଁଥିଲା ତାଙ୍କୁ କିଛି ଲୋକ ଅଟକେଇଲେ ଏବଂ ସେମାନେ ହଉଛନ୍ତି 47 ର ଆପେଲାଣ୍ଟ ଏଇ ୟାରି ଉପରେ ଆପଣ ସବମିଶନ କରୁଛନ୍ତି ଆମେ ଯିବା ବମ୍ କୁ ଯିବା ସବୁ ଆସଲ୍ଟ କୁ ବି ଯିବା ତ ଆମେ ପଚାରୁଛୁ
Page 153.
come to the evidence of PW5
Page 153.
153 ହଁ କିଏ ଅଟକେଇଲା ଦେଖିଲେ କିଏ
Next, there say two things, for other things. We found the accused Subala such and such. I
କୋଉଠୁ
saw
କୋଉଠୁ ପଢୁଛନ୍ତି
fourth line from the top. I saw started.
ହଁ
I saw the accused Rankadhara
Ah,
dealt a faster blow on the back of the Bhagirathi.
ହୁଁ
On such blow, he raised an alarm, shouting fire, and ran ahead, leaving his cycle there. The other accused persons,
ହୁଁ
that other accused persons, I will emphasize that. I will
ପଢନ୍ତୁ ପଢନ୍ତୁ ହଁ
chased after him.
Hmm.
After a distance, 2 to 3 accused persons,
Hmm.
that as a stated,
ହୁଁ
obstructed him
Hmm.
from his front side.
ହୁଁ
For this, he could not proceed further.
ହୁଁ
At that time, accused Rankadhara
assault
dealt another.
ଆସିଗଲା so again we are putting a question that at this juncture when he is giving his evidence in chief whether he has mentioned any of the appellants in that 47 hour that they obstructed him ଆମେ step by step ଯାଉ
Okay.
କହିଛି କି
No, obstruction 2 to 3 persons.
Fact of obstruction is there,
There.
and it is also by two persons, but he is not named.
Name.
ସେଇଠି that other appellant appeal on number টা কেতে 47
47.
ओके तापर आपण पळे आसंतु PW 6 1 हाउ दी टर्न तो रहला एक नंबर ऊपर आसुन तापर 6 को दिवा एक नंबर क्या की ऑब्स्ट्रक्शन कला बेली कहउछंती
Page 139.
39
139.
हां पढन को लाइन टा
Fourth
ऑब्स्ट्रक्शन
line. At this,
हाँ.
started from at this.
हाँ.
At this, Bhagirathi ran away
हम
to a little distance, throwing his cycle.
ये
The accused persons Madhu,
हम
Ladu,
हां
Vidhubhushan Patnaik
हां
obstructed him.
just a minute ताले PW1 examination in chief implicates 3 persons of 47
Right.
who have obstructed the deceased after the first assault, right?
Right.
Now this part ସେମାନେ ଆଣିଛନ୍ତି that confrontation ହେଇଛି ଆୟୋଗ କୁ ପ୍ରମାଣ ହେଇଛି ଯେ 161 ରେ ଏ ସବୁ ଜିନିଷ କିଛି ନାହିଁ ଏଇ ଯୋଉ obstruction ଏଇ ମାନେ ଯୋଉ 47 ର ମୁଦାଲା ମାନେ obstruction କରିଛନ୍ତି ବୋଲି previous statement ରେ ନାହିଁ first time in court this statement has been made, right? So now you come to PW6, a obstruction part. তারপরে যে assault, তারপরে bomb throwing.
Once 162. Para 3.
Para 3, huh?
That above was also there. But I'll start from para. There is a grocery shop. There is a grocery shop at Nuasai, belongs to accused Subala. Subala Pradhan was holding a kati, such and such. Madhav Pradhan holding a Valibhusa. Fakirana was.
Now you come to Prafula Kara, pass through this shop of Subala.
Prafula Kara PW and pass through a shop of Subala Pradhan. While Bhagirathi Kara reached near the shop, Subala Pradhan, shop Subala Pradhan, all the above 5 accused persons chased him to him. He ran away through throwing his cycle. Next, while so running, the accused Kishore Pradhan and Abhi Pradhan, Ladu Kishore, Madhu Pradhan.
These are all the appellants in 47. Achha, ठीक है. Now again, the confrontation has been made and proved, come to the evidence of that IO also. ये जो obstruction part रे, ये जो first time जो हमें माने करो submission थिला, ये obstruction part रे, PW6 रा confrontation को पढ़े आसंतु, सीधा paragraph number 24 रे अछि, page number 184. देखिए से so and so
I have examined.
हाँ नहीं तो पढ़े सुन तापर next page को 185 185 रा मझिया मझी अछि से जो सुबल प्रधान से confrontation करी ता बाहर कलो and while so running accused A4 A5 A6 A7 obstructed him from the front side देखिले से पाइले सेटा this is एटा confront हेची तांकू एवं प्रमाण हेची आईओ रे है ना so about this obstruction, if we summarize it in this way, FIR रे specifically नहीं जे किए obstruction कले खाली कुआइची 2-3 जन obstruction करे ठीक तो PW5 तार जो informant जेते बड़े कोर्ट रे डिपोजिशन करिची से मध्य कहूनी किए obstruction कले राइट 2-3 जन दी जन केवल कहिसंती ना नैचंती से दी जन होचंती गोटे होची PW1 आ गोटे होची PW6 की obstruction कले जेतेबेले प्रथम ब्लो खाइथिनी डिसीज पड़े जाउतला घटना एवं it has been confronted and proved through the IO that this was not the statement before police and so obviously it is made for the first time so this is the virtually that is their argument तापरे होला assault part
I'll pause for a moment.
Yes.
The obstruction, my submission, doesn't mean they physically obstruct. My submission. There's a congregation. The people who are congregated to one place and waiting for the term when the deceased will come. They will attack. The 34, I'll come to the 34. How they have in a conflict intention to attack and they prepared in a premeditated mind with weapons. It is not all and sudden that brought out weapons and started. They were armed with the weapons. And there are, I have just submitted for kind of appreciation. The assault part in the first instance and the second part, there are just a little distance. And the first assault made in a places in front of the Subal Pradhan. They run away and somebody is obstructing just ahead, few feet ahead.
Obstruction heichi beli evidence achi.
Obstruction my submission would be
who has obstructed it, whether the evidence is there ନା ଆପଣ ଯେତିକ ଅଛନ୍ତି ସବୁ ତକ accused କୁ ପକେଇ ଦେବେ
ନାଇଁ ନାଇଁ ମୁଁ
ଆପଣଙ୍କୁ specific
just kind of appreciation
ହଁ।
obstruction how there ଯେତେବେଳେ once he was leaving the place by run away thereafter also the bomb was exploded.
No, there are two folds.
Two folds.
The whole episode is twofold.
Yes.
One episode when the assault was made and the person by then has died. When the villagers started coming over to the spot, there was hurling of bomb. So this hurling of bomb might have restricted the people of the Sahi to come to the spot. So this is an obstruction. This is one part of obstruction. Now we are in the place where the assault was being made and he was trying to flee away. He was stopped by obstruction. So who has obstructed? The fact of obstruction is there. But what is the evidence? Who are those persons who obstructed? Is it those who have been named? So the name that has come not in the FIR for the first time before the court in evidence through two witnesses, and these two names which have come in evidence have been contradicted through the IO, who says that these names have not been stated by the witness before me.
161.
So when the witness for the first time gives the name in the evidence, what should be its
Evidentiary value.
that is only you.
Then I will satisfy on 34 how they will come.
But the obstruction with regard to the hurling of bomb and they were restricted from coming to the
Yes.
spot is the other part. By this time, the deceased has died.
That this is here is that only stated truth, not named. It is a fact.
Right.
But thereafter, then I will bring to the lordship question post, even though they are not named in the assailant
Correct.
part, how they have been convicted 302.
Right.
Then I will satisfy after the
Right.
placing the judgment and other evidences. Your lordship, that
Now if obstruction goes, then comes actual assault.
actual.
ତାପରେ bomb throw ତିନିଟା ତ part ହେଇଛି ଆଉ
ତିନିଟା।
ଆପଣ ଯୋଉ 40 we are discussing about the 47 accused.
Yes.
We are because 47 and that too 302 by 30.
ହଁ।
ବର୍ତ୍ତମାନ discussion ଟା ହଉଛି ସେଥିପାଇଁ
ଆଜ୍ଞା
argument ସେଇଟା ଇଏ କରନ୍ତୁ ତାପରେ ଯିବା bomb
Assailant।
ତାପରେ
Assailant।
ଏମାନଙ୍କ ଯୋଉ main ଯୋଉମାନଙ୍କର ନାଁରେ
Assailant
assault ଅଛି
କିଏ?
who are in ସେଇଟା ତେଣୁ ବର୍ତ୍ତମାନ actual assault ଦେଖନ୍ତୁ actual assault ଆପଣଙ୍କର FIR ରେ ଅଛି
Yes.
whether the 47 accused persons have been implicated in the actual assault of the deceased.
In the two names have come out subsequently.
One Avi,
One of the and another is
No, no, please come to the FIR.
Come,
Please come to this.
only Avi probably has come. No.
FIR କୁ ଆସନ୍ତୁ ଆପଣ actual assault on the deceased.
evidence ରେ ସେମାନେ ତା ନା ଆସି
ନାଇଁ ନାଇଁ ଓହୋ ଆପଣ ଯିବା ପୁରା step by step ତରତର ହୁଅନ୍ତୁନି. We have taken note of it about the obstruction. Now we are coming to actual assault. Actual assault ର FIR କଥା କୁହନ୍ତୁ ତାପରେ ଯିବା ଗୋଟି ଗୋଟି ତିନିଟା ଚାରିଟା ତ ତିନିଟା ସାକ୍ଷୀ ଆଉ FIR ଏତିକି ତ ଦେଖିବ ଆଉ ହଁ ସେଇଠିକି ପଳେଇ ଆସନ୍ତୁ ଯୋଉ
ମୁଁ କୋଲେକ ପ୍ରଧାନ ସାଇକେଲ କ୍ୟାରିୟରରେ ବସିଥିଲି
ହୁଁ।
ଆମ୍ଭ ଗ୍ରାମର ସୁବଳ ପ୍ରଧାନ ଗୋଟିଏ ତାପରେ
ପଢନ୍ତୁ ପାଇଲେ
ମୁଁ
page-
ଗୋଲେକ ପ୍ରଧାନ ସାଇକେଲରେ କ୍ୟାରିୟରରେ ବସିଥିଲି ଆମ୍ବ ଗ୍ରାମର ସୁବଳ ପ୍ରଧାନ ଗୋଟେ କେବିନରେ ମସଲା ଦୋକାନ
ହୁଁ।
ତାର ଘର ସାମ୍ନାରେ ପକାଇଛନ୍ତି
ହୁଁ।
ଆମ୍ଭେମାନେ ସୁବଳ ପ୍ରଧାନ ଦୋକାନ ପାଖରେ ପହଞ୍ଚି ଦେଖିବାକୁ ପାଇଲୁ ଯେ ଆମ୍ବ ଗ୍ରାମର ରଙ୍କ ନୀତି that is 193
ସବୁଗୁଡାକ 190
ଦଣ୍ଡ
ଆମେ
90
ଚେକ୍ ଅଫ୍ ହେଇଯାଇଛି
ଦୁର୍ଯ୍ୟୋଧନ ମାଧବ ମିଶି ସୁବଳ ପ୍ରଧାନ ଦୋକାନରେ ଜମା ହୋଇଥିଲେ
ହୁଁ।
ଗୋଲେକ ପ୍ରଧାନ ଯିଏକି ସାଇକେଲ ଦେଲା ସୁବଳ ପ୍ରଧାନ ଦୋକାନ ପାସ୍ କରି କିଛି ବାଟ ଆଗେଇ ଗଲେ ତାଙ୍କ ପଛରେ ଭାଗୀରଥୀଙ୍କର କିଛି ଅନ୍ତରେ ଆସୁଥିଲେ
ହୁଁ।
ରଙ୍କନିଧି ନାୟକ ଯିଏକି ଲୁକାୟିତ ଭାବେ ଫାର୍ସାଟିଏ ଧରିଥିଲା ସେ ଭାଗୀରଥୀ କରକୁ ଦେଖିବା ମାତ୍ରେ ଭାଗୀରଥୀଙ୍କର ପିଠି ପଟକୁ ଚୋଟ ମାରିଲା
ହୁଁ।
ଜୀବନ ବିକଳ ଦୌଡ଼ିବା ଆରମ୍ଭ କଲେ ଆମେ ଦୁହେଁ ଜୀବନ ଦୌଡ଼ିବା ଆରମ୍ଭ କରନ୍ତେ ଗାଁର 2-3 ଜଣ ଲୋକ ଭାଗୀରଥ କରକୁ ଜଗି ଦେବାରୁ
ହୁଁ।
ସେ ଆଉ ଆଗକୁ ଯାଇପାରିଲେ ନାହିଁ
ହୁଁ।
ଯେଉଁମାନେ ଜଗିଲେ ସେମାନଙ୍କ ନାମ କହିପାରିବେନି ଚିହ୍ନି ପାରିବେନି
ହୁଁ।
ପରେ ରଙ୍କନିଧି ଫର୍ସା ଦ୍ୱାରା ଭାଗୀରଥଙ୍କ ଫର୍ସା ଆଣିଦେବାରେ ତାର ବାମ କାନ ଅଧା ଛିଡି ଯାଇ ଅତି ଜୋରରେ ରକ୍ତସ୍ରାବ ହେଲା
ହୁଁ।
ଭାଗୀରଥୀଙ୍କର ମାରାତ୍ମକ ଦ୍ୱାରା ଆହତ ହୋଇ ରକ୍ତାକ୍ତ ଅବସ୍ଥାରେ ତଳେ ପଡିଲା ଏହାର ସୁଯୋଗ ନେଇ ତାକୁ କାଳୁ ଓରଫ ଦୁର୍ଯ୍ୟୋଧନ 193 ଫର୍ସା ଧରିଥିଲେ ଦଣ୍ଡୁ ପ୍ରଧାନ ଫାର୍ସା ଧରିଥିଲେ, ସୁବଳ ପ୍ରଧାନ କାତି ଧରିଥିଲେ। ଏଇମାନେ ଭାଗୀରଥ ଚାରିପଟୁ ଆକ୍ରମଣ କରି ହାଣିଦେଲେ। ଏହାପରେ ମାଧବ ପ୍ରଧାନ ଯିଏକି ଭାଲିଭୂଷା ଧରିଥିଲା, ସେ ଘଟଣାସ୍ଥଳରେ ପହଞ୍ଚି ଉପରେ ଲେଖା ହୋଇଥିବା ମୁଦ୍ରାଙ୍କ ସହଯୋଗ କଲେ। ପରେ ପରେ ତାଙ୍କ ଦଳର ବହୁତ ଲୋକ ଘଟଣାସ୍ଥଳରେ ଜମା ହୋଇ ଦେଖି ଆମ୍ଭମାନଙ୍କ ମନରେ ଭୟଜାତ ହେଲା। ଆମ୍ଭେ 2 ଜଣଙ୍କୁ ମଧ୍ୟ ପ୍ରାଣରେ ମାରିଦେବେ। ଆମ୍ଭେ 2 ମୁଦାଲମାନଙ୍କର ଅନ୍ୟାୟ କାମ ପ୍ରାଣ ବିକଳରେ ଏବଂ ସାଇକେଲଟିକୁ ଛାଡ଼ି ଦେଇ ସାଇକେଲ ପଳେଇ ଆସିଲୁ।
ଘଟଣାସ୍ଥଳରେ ଭାଗୀରଥୀଙ୍କର ତୀକ୍ଷ୍ଣ ସ୍ପର୍ଶ।
ଆଜ୍ଞା।
ତ ଏଇ ଯୋଉ ନାଁ ଗୁଡାକ ପଢିଲେ, ଯୋଉମାନେ ଆକ୍ଚୁଆଲ ଆସଲ୍ଟ କଲେ,
That is 193.
ସବୁଗୁଡା 193 ପାଇଁ ଆପଣ ପଚାରୁଛୁ। ତ
ଆଜ୍ଞା।
FIR ରେ ଆକ୍ଚୁଆଲ ଆସଲ୍ଟ ରେ none of the names of the appellants of 47 finds place. ହେଲା, ବର୍ତ୍ତମାନ PW5 କୁ ପଳେଇ ଆସନ୍ତୁ, ସେଇ ଆକ୍ଚୁଆଲ ଆସଲ୍ଟ।
Platform 152.
152
152.
ହଁ କଣ?
Accused Subal Pradhan had an own cabin in front of his house where he was running a grocery shop. When we passed through his cabin, found the accused Subala Pradhan, Madhav Pradhan, Dandu Pradhan, Rankanidhi Naik, Durjodhana Naik,
They are all 193.
193 assembled there. After crossed the
After
cabin,
we crossed.
after we crossed the cabin, Bhagirathikar while passing that cabin, having followed us, I saw the accused Rankanidhi dealt a farsa blow on the back of the Bhagirathi. On such blow, he raised an alarm shouting, "Hi, on ahead," leaving his cycle. There the other accused person chased him. After some distance, 2 to 3 accused persons obstructed him from his front side. Even though, in fact, no name. For this,
नेम तो नहीं होती कोई।
he could not proceed further. At that time, the accused Rankanidhi Naik dealt farsa blow on his left cheek, and so Bhagirathi fell down and dragged to the little distance. Due to this blow, he sustained a cut inside wound on his cheek, leading from his mouth to ear. His left ear also severed due to the said cut inside. Next part.
This is most important. Again, good assault.
Accused Subala Pradhan
Was holding Kati.
193.
Dandu Pradhan was holding farsa.
Again 193.
Kalu Pradhan was holding farsa.
193.
Madhav Pradhan was holding farsa.
Madhav was holding a
Holding Bhali Bhusa. They surrounded Bhagirathi and assaulted by means of the weapons to the person indiscriminately. Thereafter, many persons
They assembled.
were assembled there. Seeing this, we left the place.
So PW5 not named the appellants
In 47 to the main assembly.
47 as the main assailants of the deceased. Right, but on PW1 person.
Then 5, para 5.
कौन para 5?
PW1 रो.
Para 5 तो bomb पता bomb को हम
Yeah,
asking
bomb
पर
को
आपको PW1 person.
132. On the day of 28th,
No, no, on the. I was coming ahead of Bhagirathi.
सिर्फ पढ़ो जो मारा कथा जो अच्छी.
I was coming ahead of Bhagirathi. Accused Subal Pradhan was carrying a grocery shop in a wooden cabin in front this house. In front his house. There I found gathering accused Ranka, Subala Pradhan, Madhav Pradhan, Dandu Pradhan, Kalu Pradhan Ali Durjodhana were standing in front of his shop of Subala. I crossed him, and thereafter Bhagirathi passed. While passing them, accused Ranka Naik suddenly dealt a farsa blow on his back and Bhagirathi. At this, Bhagirathi ran away a little distance, throwing his cycle there. Accused Madhu, Ladu,
এটা যে obstruction part টা ଆପଣ ତ already
ଆଜ୍ଞା।
କହିସାରିଲେଣି।
ଆଜ୍ଞା।
Then
You
I
are
can
nine.
come down.
Then come down.
He fell down there.
and
At
for
this.
at this
Accused Ronco.
accused Ronco,
Assault on
Ronco Nidhi Pradhan assaulted the deceased by means of farsa
ঠিক।
on his left.
Yeah.
The left ear was half severed from its place. Again says that when the aforesaid three accused persons, accused persons obstructed Agirati, then three accused person out of that 47 mentioned above. That then obstruction that mentioned. Obstruction of Agirati,
Accused Ronco.
accused Rankanidhi came and dealt farsa blow and his left ear on his left ear, and so he fell down on the ground. So here the obstruction attributed to above the out of this three.
That we have already done. No? Yes. Next.
Now you
Para
come.
3.
This is most important. We are now on
Accused Ranko Naik,
193,
Subal Pradhan,
193,
Dandun Pradhan,
193,
Madhav Pradhan,
193.
Vidubhushan
This
Patnaik,
is the name, only name
Hmm.
of 47 he has stated along with this 6 and 7.
Ladu,
हाँ एटा पढ़ंतु बर्तमान तीन जनकर ये इम्प्लिकेट कला
Aଜ୍ଞା।
ए जो
Vidubhushan.
ए
Vidubhushan,
A2
Ladu
A6 and A7
Aଜ୍ଞା।
that they assaulted along with the other.
Aଜ୍ଞା।
ঠিক আছে।
Madhuta A7,
A7. Yes, yes.
Ladu A6.
ତିନିଟା
ହଁ।
47 ର 3 ଜଣ accused with 4 ଜଣ accused of 193
Right.
they assaulted by farsa blows to this one ହେଲା
While he was leaving the ground,
Hmm.
they dealt farsa blow surrounding the deceased. If they will be interpret here, then it will cover to all the accused persons they are named as.
Now you come to the cross examination.
I just took the 3 lines.
No.
They dealt farsa blow surrounding deceased. Accused Subal was holding Kati
Yes.
and accused Madhav was then holding Bhalibhusa. Subal was holding Kati and others who are holding farsa. If and others will be, my lord will be treated it in reading in conjoint with the named above in above para 2. Those only. That can be also inferred then 34 will come into place. On such assault, Bhagirathi died at the spot. On seeing them, I ran away.
मधु प्रधान तार केते नंबर की आप
A7.
Madhu A7.
अच्छा A7 ओके नाउ एटा तो पढिले एई माने जो 47 नो जो तीनटा ना आसिला एटी असॉल्ट करले बेली
Aଜ୍ଞା।
दैट इज विधुभूषण लडू आ मधु
मधु।
तीनटा ना बर्तन पढे आसंदु पेज 184 आईओ रो कन्फ्रंटेशन जो हिगिन प्रूव होई
Aଜ୍ଞା।
कम टू पैराग्राफ नंबर 21.
I have examined.
I have examined PW1 पढ़ंदु
PW1. He has not stated before me that accused Subala was also present there.
पढ़ंदु तापर डाइटा दिस इज
He has not stated before me that accused Madhu Pradhan, Ladu Kishore, Vidubhushan obstructed Bhagirathi when he was running away. He has not stated before me that the name of Vidubhushan Patnaik, Madhu Pradhan and Ladu Kishore in any connection.
देखिले ना
Aଜ୍ଞା।
तो जो तीन जनकर ना आपण
Assault रे
आनिले असॉल्ट रे ठीक इन एनी कनेक्शन मतलब 161 ने टोटली ही ना
नहीं,
which one
unconnected to 160.
so PW 84 para ବର୍ତ୍ତମାନ PW 6 କୁ ପଳେଇ ଆସନ୍ତୁ ସେଇ ମାଡ ପାଖକୁ ଆସନ୍ତୁ paragraph page number 162 paragraph number 3 ना पढ़ो
While so running, accused Kishore Pradhan, the accused Kishore Pradhan and
तो
Abhi
देखिले जे ऑब्स्ट्रक्शन वाला जो 47 नो
आगे।
4 जण ना कहिजी सेटा नाही तापर पढंतु माड कथा मध्ये अछि तां कहिजंती
Kishore Pradhan, Abhi Pradhan, Ladu Kishore, Madhu Pradhan obstructed.
Hmm.
8 obstruction they are stated.
अरे,
Hmm.
obstruction
The
ଟା
front,
All of
then accused Ronko Naik dealt Farsa blow, which fell on his left ear
Hmm.
from his backside. On this blow, the deceased Bhagirathi Kara fell down. On his falling down, accused Abhi,
ते 47
Yeah.
वाला
Madhu,
47
Ladu Kishore,
47
Kishore Pradhan,
Kishore is 47
47, and Ronko.
Ronko 47
No,
No,
Ronko is
193.
193
Yeah.
Ronko
Ronko.
अच्छा right हाँ Ronko टा was 193
Duryodhana,
Duryodhana
193.
193
Subala 193,
193
Madhava,
193.
193
Madhusudan,
and nine
Vidubhusana,
Vidubhushan which 147
assaulted him
him
indiscriminately with their respective weapons.
Hmm.
All the aforesaid accused persons are present in the court in the dock.
तापरे
Some
तापरे बॉम्ब आसला वर्तमान पळी आसंतु आपनकर आईओर एविडेंस कन्फ्रंटेशन पैराग्राफ नंबर 24 पेज होची 185 185 रो लास्ट पांचो लाइन को देखंतु 185 को आसिले
he has not stated.
Hmm.
हां सेठी पढ दियन
Stated before me that Bhagirath sir having fallen down, accused Ravi Pradhan,
हां एटा 47 वाला
Bhagi Pradhan, Ladu Kishore,
लॉर्ड किशोर 47
Kishore Pradhan,
47
Duryodhan Pradhan, Madhav Pradhan,
47
Vidubhushan Patnaik
हाँ.
assaulted him indiscriminately
Hmm.
with their respective weapons.
So this is also not there. ତେଣୁ actual assault ରେ ଯଦି ଆପଣ ଦେଖିଦେବେ contradiction କୁ ଇଏ କରିକିନି consistency ଆସୁଛି ଯୋଉମାନେ
190.
Appellant.
190 ବର୍ତ୍ତମାନ ତାପରେ ରହିଲା ଯୋଉ ବମ୍
Bomb
ବମ୍
part,
ଥ୍ରୋଇଂ
well.
ବମ୍ ଥ୍ରୋଇଂ ପାର୍ଟ ର ମିଷ୍ଟର ଯୋଉ କେତେ ଜଣଙ୍କର ନାଁ ଆସୁଛି and that is also consistent କିଛି addition ହେଇଛି ଅଲଗା. Now the question is the pivotal question which we are asking you, that suppose ଆମେ obstruction ରେ କିଛି ରୋଲ ନାହିଁ ବୋଲି ହୋଲ୍ଡ କରୁ, we are just giving you all.
Aye.
assault ରେ କିଛି ରୋଲ ନାହିଁ ବୋଲି ଆମେ ହୋଲ୍ଡ କରୁ, ସେତେବେଳକୁ ଡିସିଜ ମରିକିନି ପଡିଛି, ତାପରେ ଇଏ ପଳେଇ ଯାଇଛି PW5 ଗାଁ ଲୋକଙ୍କୁ କହିଛି, ଗାଁ ଲୋକ ଯେତେବେଳେ ଆସିଛନ୍ତି ଗାଁ ଲୋକଙ୍କୁ ଅଟକେଇବା ପାଇଁ ବମ୍ ପକା ହେଇଛି
Second part of it.
ସେକେଣ୍ଡ ପାର୍ଟ, ଯଦି ସେଇ ପାର୍ଟ ରେ କିଛି ଆକ୍ୟୁଜ୍ଡ 47 ର ନାଁ ଆସୁଛି, whether
They can be
they would be entangled in the case
Of original murder.
302 with head of 30.
30.
ଯଦି ଆମେ ଏଇ ସବମିଶନ ଆପଣଙ୍କର ଆକ୍ସେପ୍ଟ କରିବୁ, ହେଲା, by that time main occurrence is over, dead body is lying there, villagers are coming to the spot, bombs were thrown. Just answer.
So the overtake with regard to the hurling of bomb to the people
Who are
when
coming,
they
the
started
villagers
coming
coming
to
to
the spot
Right.
would amount to overtake in furtherance of common
Common
intention of assault.
With that, I will bring to Lordship section 34. It is not disputed that the place of occurrence is a very confined place. In the Subal Pradhan shop, in the road, in the open place.
Mhm.
And some of the houses are there. It is not also not in dispute in factually that which persons belongs to the village, same village of the same locality. So it is not only obvious but natural people will be sit together and talking something in the village. Here is the case when the assault started in one part and the villagers while coming to the spot, others are throwing bomb. Obstruction they are not named, but some of the persons out of that congregation of that village throwing the bomb to obstruct the people not to proceed to the
Spot.
occurrence spot. So it cannot be said they are in isolation with the assailants.
After the
That's and I'll come to that. I may repeat, I'll come to that.
So it is in sequel to that. It is in sequel to that according to
Yes.
you.
It is because in order to bring home the cause of 34, we have to in common intention and meeting of mind, two things are required. Even though meeting of mind, the evidences are not there, but here the intention among the perpetrators is required to be taken into account how they have committed the crime. It is not the evidence of anybody, not defense is there. This other person, though are not in the 47, though are 47,
Right.
not came subsequently after the occurrence from other places. They were very much present there. And they hurled the bomb in the spot just around a few feet in distances. So in order to bring home the charge, then after act done by several persons in furtherance of common intention. I am just placing for your spot. When the criminal act is done by several persons in furtherance of common intention of all, each of such person, if each of person liable for the act will be interpreted, my humble submission for your lordship, your kind person, each of such person is to be taken into consider the person who has participated in the assault part and who were present there and watching the situation, who were coming there for their rescue. So all those persons of 193, 147, they are having the common intention. Otherwise, they would not have been prepared with the weapons of bomb. Even though it is admitted that the spot named is not there who has obstructed, but inference can be drawn from other sources that has been described in the judgment, how they have obstructed. These people who were present there, so it should be inferred from their presence that they were obstructed the Bhagirathi. Even though evidences are not there, directly linking they are obstructed. Once they were present, their presence in the situation of occurrence is admitted. Their presence with the congregation of the peoples is also admitted.
Who has admitted it?
Admitted position.
What
At the
does it
same
mean
time,
admitted?
then at the same time, the places where the inference are just trying that inference to be drawn that they were present in the place of occurrence.
You see, their names were not coming till the bomb stage comes.
Yes.
ଆପଣ ଯଦି FIR ଦେଖିବେ ଆଉ ଏଇ ଯୋଉ ତିନିଟା ସାକ୍ଷୀଙ୍କର ଯଦି ଏଭିଡେନ୍ସ ଦେଖିବେ ମାଇନସ୍ କରିଦେବେ କଣ୍ଟ୍ରାଡିକ୍ସନ ଯୋଉଗୁଡାକ ଆଇଓ କହିଛି ତାଙ୍କର ରୋଲ ସିଧା ଆସୁଛି ବମ୍ ପକେଇଲା ବେଳେ ଆଉ ବମ୍ ପକେଇବା ଷ୍ଟେଜ କୋଉଠି ଆସୁଛି ନା PW5 ସେ ଘଟଣା ଜାଗାରୁ ଦୌଡ଼ିକିନି ଯାଉଛି ଗାଁ ଲୋକଙ୍କୁ କହୁଛି ଗାଁ ଲୋକ ଆସୁଛନ୍ତି ସେତିକି ବେଳେ ବମ୍ ର ସିକ୍ୱେନ୍ସ ଆରମ୍ଭ ହଉଛି ତା ପୂର୍ବରୁ ତ ବମ୍ କିଛି ନାହିଁ ନା ତେଣୁ ଆପଣ ଯୋଉ କହୁଛନ୍ତି ନା ସେ ପ୍ରଥମରୁ ଥିଲେ ପ୍ରଥମରୁ ଆଉ ଯୋଉ କିଛି ଲୋକ ତାଙ୍କୁ ଅବଷ୍ଟ୍ରକ୍ସନ କରେ ତେଣୁ ପ୍ରିଜ୍ୟୁମ କରାଯିବ ବା ଇନଫର କରାଯିବ ଯେ ସେମାନେ
So the evidence which is not before us and you intend the court to take an inference, let us not go by that also. No evidence, no inference. Simply the evidence is that these group of people are the people who have been named through the bomb after a while obstructing those people to come to the side. Whether this amounts to a common intention. That is the only thing. Beyond that, you cannot say.
Why is it common intentional lordship? Suppose they were no way related to the occurrence, and somebody is going ahead to proceed their places to the occurrence either to save the people or
Right.
do something.
Right.
When they were obstructing by they would have been inference, it will be drawn. They are with the common intention with other assailants.
You could have argued that also. Suppose an occurrence is going on, assault is going on, by that time some persons are coming to save the deceased, and at that point of time the obstruction is created by throwing of bombs so that those persons would have, if they would have come, they would have saved the deceased, right? So that is not the case here. Here is a case is a totally different. By that time the occurrence is already over. That means the assault over, the dead body lying, this man is going to inform the...
So Mr. Manti, why not we have an inference that this obstruction of these people to the Sahi people to avert some kind of untoward incident after the death?
Yes.
The person has already been killed and these people are having seen the entire episode. These people have gone to the Sahi. That is the evidence. These witnesses having seen the entire episode of assault, when they found that this man died, they ran to the Sahi. And Sahi people are coming thereafter, and there is an obstruction now.
That's it.
So why not the inference be drawn that in order to avoid a situation of untoward eventuality, these obstruction could be there.
Yeah.
Why it will be linked to the
Main.
because by then it is dead. He is
If
dead.
that proposition will accept, in order to avoid the further aggravated situation,
Because already there is an
the-
incident.
it cannot be used by bomb. Because it is not.
Mode means would be different. You come
It cannot be
mode means could be different.
If somebody is having with a bomb
Correct.
and thrown at the place to obstruct the people's, it is clearly intention is proved that they were prepared with the arm and ammunition.
All right. Right.
So
So,
that's
according to you,
You have been found guilty for that also.
so yes. So that means they were prepared.
Prepared.
The preparation was there.
There. So when the preparation is there,
Yeah.
and in a part of commission of offense by the assailant 193, and a person, so those are coming to the person, it was not known to the villagers whether he was dead or alive.
Right.
If it was not the treatment at the time of proceeding the people, he was dead.
No,
They have
it is
assaulted
there
him.
in the evidence. It is there that by the time the people were informed in the Sahi, he was already dead.
But it was nobody's
Anyway, but the
But-
preparation was there.
preparation was there. When the preparation with a common
Mr.
intention,
Mahanti, there are some villages, we are not naming it. And in every household you will find bombs there.
no, that
And in
I'm
those
talking
areas,
with my
cases
friends.
you would have-
Into the place person with the assailants.
Right.
So
Question
they are very clear.
question is whether you say that preparation,
Yes.
question is whether they were prepared to assault the deceased
They-
or prepared to restrict somebody
Restrict, yes.
after. So
Yes.
that is
That's when the class of war is going on in some of the groups, the 2 to 3 parts. Who will assault, who will obstruct, and who will save. These are the 3 things being done in any class of groups. Suppose they have decided because common intention, they have prepared themselves with arm and ammunition, some of the deadly weapons, some of the bomb, some of the lathi. When the assault was made, they are prepared. If they will come, then we will obstruct. It may be late in some time after the assault, but it cannot say obstruction as your lordship proposes by way of throwing bombs. Whether they would have obstructed, no, go to there are some untoward incident happened. Please stop here. If they would have, they would have attacked by them something otherwise that they had also with that intention to cause attack to the other assailants. So in 34, I'm saying every case is not the possible of direct evidence. So,
Yes.
so the evidence of a common intention, it has to be the inferred from the fact and circumstance of these cases.
Yeah.
That doesn't do. Here is the fact and circumstance. My humble submission. Once the persons present there, after the assault being made on the deceased, and the other persons came to there, they have throwing the bombs. So the common intention well proved, well prepared. They were in a assemble each other in the house in front of the shop of the Subal Pradhan, who is also the assailant in one ground and in the appellant 193. And furthermore, the existence of the common intention is a question of fact also. When the common intent fact, and the court has to infer intention of the acts done by and committed by the others. The learned trial court in his vividly has examined, described in the report how the 34 will came into operation against the all accused persons. That's why they all have convicted under 302.
So the trial court must have also taken into account that they were the participants in
Yes.
obstruction.
Yes, yes.
They were the participants in the assault, and they were the participants in throwing a bomb.
Is it?
Is it on
Is it
34.
34 ku?
what my lord said? Is it that the trial court has taken into account the participation of these appellants in 47 in the assault, in the obstruction, and then throwing bomb? Whether all these things have been taken or isolatedly only throwing bomb?
No.
Leading
No,
to 34.
not isolation.
So all the 3.
Not the 3.
Para 27, they have mentioned. In the isolation of appellant of 193 and 147, how they have caused the crime by a common intention with meeting of mind. That's why they have.
Because why we are saying this on a threadbare assessment now on the argument that you have placed, apparently it shows that in some cases where the implication of the persons in A 47 is not there initially and they have been implicated subsequently. So the only aspect of overtake that we find in the case is with regard to the hurling of bomb. So if the trial court has taken all these three things together, obviously it would amount to 34. But isolatedly, as you now submitted, that even if it is a different act altogether, not in the question of assault, also it will amount to an overtake in furtherance of common.
Even if we exclude
Even if we exclude.
the two.
Reason being there is a preparation to the original. This is your argument. Yes.
So I'll just place that judgment, the description of that, how the
34. Phone.
then I'll place
You just give a ଆପଣଙ୍କର note, short note ଟେ ଦେବେ, citation ର ଯୋଉଗୁଡାକ ଦେବେ, ମନେକର 34 ଉପରେ ଆପଣ ଯୋଉ decision ଦେବେ, decision ଖାଲି କୋଉ paragraph ଟା relevant ସେଟାକୁ indicate କରିବ, not that ପୁରା ଦେଇକି ହଁ। ଆଉ ଯୋଉ written note ଦେବେ ତା ଦେହରେ factual aspect କିଛି ଲେଖିବା ଦରକାର ନାହିଁ, କାର story ଏ ଅମକ ଢମକ ଏଗୁଡା ସବୁ ଦରକାର ନାହିଁ, to the point ଇଏ କରିକି ତାଙ୍କ ଇଏ meet କରିକି ଦିଅନ୍ତୁ। Yes, କଣ କୁହନ୍ତୁ 34 decision କୁହନ୍ତୁ।
2008 3 SCC 390
party नाम कौन?
Sachin versus State.
सचिन तो हाँ
The existence of common
just
intention.
two paragraph को अच्छा ठीक है all right पढ़ो।
The existence of common intention among the participants in a crime is the essential element of application of this section. It is not necessary that the act of the several persons charged with the commission of offense must be a similar act in identical manner. The act may be different characters, but must have been actuated by one or same person with intention to attack the provision. Then 1999 3 SCC 102.
1999
3 SCC 102.
ना कौन?
Nanda Kishore versus State of Himachal Pradesh.
हाँ पढ़ो कौन?
In every case, it is not possible to have direct evidence of a common intention. It has to be inferred from the fact and circumstances of each case. Then 2011, volume 12 SCC 319.
2011 volume
12 SCC 319. The existence of common the patinata that I will intimate as
okay ठीक है पढ़ो।
The existence of common intention is a question of fact, and the court has to infer intention from the acts and conduct of the accused persons, as it is very difficult, if not possible, to get in direct part of evidence. 2008 volume 3 SCC 390. That's the inference common intention.
That has been relied upon there. Okay.
The act need not be overturned. 2001 3 SCC 673. Suresh versus State of Punjab. 1997 80 SCC 405. Dukhamochana versus State of Bihar. Such intention could be formed previously or on the spot during the progress of crime. It is not that the intention, in the progress of crime that intention will come. 2000 volume 4 SCC 603. It is not material to bring under section 34 who inflicted the fatal blow. Even the person present and participated in some way under 34. So far the 34 is concerned, these are the result. If any other found, then I will be
okay.
The omission and the entire argument advanced by all my esteemed seniors, and omission and commission and contradiction. But so far the evidences of 1, 4 and 5, the direct eyewitnesses, in no way has been disproved in any way by way of a judgment which has been by the trial court, dealt with in the trial court judgment. Minor omission do not offset the case of the prosecution. The case cannot be taken, the case cannot be taken on the ground in reject of the prosecution
No,
of the
that is principles we are there, principles we know.
And even also that I'll judgment that in the laches in part of the investigating officer cannot take away the prosecution.
No, what is your reply to the submission which was advanced by Mr. Dhar? First of all, he's raising a thing that the place of occurrence is doubtful in the sense that the IO comes to the place after 2 hours, or let us say.
No, 9:30.
2 to 3 hours.
Whatever.
Exactly.
On the very day.
And on the very day, and the person, the deceased was coming in a cycle with some vegetables, and he fell down there, and he was assaulted. So the IO says that I did not find either the cycle or that bag with vegetables or even the bloodstain at the place. So that is their submission that at such a place the occurrence has taken place that is doubtful. So what is your submission?
Yeah, IO has, even though absent, he has seized some materials from the spot with the bloodstain that stick on other things. When this in one part or some of the evidence he has seized some materials from the spot. It cannot be said in isolation if other is not absent, the spot is doubtful. The evidences are there in the spot, in the evidences are there, he has also cross-examined. The spot to say bloodstain at the nation, para to of their evidence.
What about the cycle?
The cycle is PW5. Their cycle is because the mob was there. What is cycle? PW5 goes in the PW5 statement. Cycle that is cycle one of the accused are thrown to the well. But it is not the statement what density of water was there, whether IO was verified that water or not. It is present. That evidence is not there. Once the evidence is absent on that line, it cannot be now advanced that the IO was not seen. That would have been asked at the time of trial. The trial is conducted such a genius trial law of this state. That
Okay, what about the submission that PW6, who claims to be an eyewitness to the occurrence, and he was very much present at a nearby place, and the investigation started from the date of occurrence, and he was examined 4 days after. So about the delayed disclosure before the police, they were saying that PW6 in the meantime has been planted to be an eyewitness to the occurrence. Had he have the knowledge about the occurrence, he would have come voluntarily to the police to disclose on the same day or next day because the police was available. So, but he gave his statement on, I think, second day statement. So
but it is not disputed that PW1 and 5 was examined on the same day.
No, I'm about the PW6.
So, 6 is concerned. It is
Fourth day.
on 2.
28th was incident,
2 was examined.
29th first went, then second.
Then he explanation in the evidences he has given by the IO. He was that busy in other words. And I'm just coming to that.
PW5 IO evidence देखिले सी सेदिनो थिला 8 तारीख थिला 9 तारीख थिला एविडेंस रिकॉर्ड करथला सॉरी 8 तारीख होची हमरो 28 तारीख थिला
पेज 178 में कले ग्लास ये IO स्टेटमेंट
178.
PW5 को जो 15 दिन कंटिन्यूअसली आयो असता.
हां
No, no,
5 days
5 दिन
ପାଞ୍ଚ
नहीं एविडेंस होची 15 दिन असले.
ନାଇଁ ସେ ଆସିଥିଲା 15 ଦିନ but he was there in the village for 5 days.
से कोन करिछि को दिन मध्य सेटार एविडेंस अछि को दिन इनक्वेस्ट करछि कोन सीजर करछि कोन स्टेटमेंट कहूछि से डिटेल माने एई दिन ये करछु. So the submission is that if he was coming to the village of the
The
occurrence according
explanation is
the,
given.
huh?
The
Yes,
explanation
178.
178.
कुहतु
Prafulla Kara gave his statement openly and to be heard, hearing of others. Immediately after the recording of affair, I examined Udaya Kara PW4, Golok Pradhan PW1 and the very place. At that time, I wanted to examine some more eyewitnesses, that's important.
Hmm.
But none of them were available for the examination.
Hmm.
So I am not sure if those persons were present and they did not voluntarily at the time to give a statement, and on subsequent occasion they came to offer their statement to me. At that time, I tried my best to examine the eyewitnesses, but however, they were not made available to me for examination. I record the statement of Uday Kara first, then statement of Prafulla Kara, and thereafter the Golok Pradhan PW1. Even after examining these three witnesses, they did not disclose to me about their any other witnesses to the offense. So the three witnesses examined. After 4 days examination of three, does not fatal the prosecution because they have not embellished anything, in added some things. Whatever statement recorded implicating the accused persons in 193, same in the by the 6. If he would have been an interested witness to implicate the other accused persons in different manner, it would have been inferred that he has been interested witness or belated. The mere belated examination of witness, there is judgment, cannot be fatal to the prosecution or take away the entire prosecution case if it has been elicited from the mouth of other witnesses.
No, you say that, but in fact, PW6 ro deposition upon jodi dekhibe chief ro examination ता धीरे जदियो से कहा कि ना जो अपन देखिले ना 47 नो कहा ना कही नदिला 161 ने कोर्ट रे सेमानकर ना ऑब्स्ट्रक्शन ने सेमानक ना एक्चुअल असॉल्ट रे ये सब ताकू आनीची तणु आपण जो ताकू कहउछंती ना जे फर्स्ट टाइप ही हैज added anything he has that is not correct in fact
नहीं assault part consistent between amongst the other eyewitnesses. It is consistent. So far, the obstruction and throwing of bombs.
No.
There is a difference.
He has also implicated these 47 accused persons in the assault of the deceased in paragraph number 3. That has been proved that he has not.
So here the question of delay.
Example.
We are asking you about that delay. Raising a point
that once the evidence that nobody was found there present to examine, and it was not suddenly brought to the notice of the IO who are the other eyewitnesses. By course of investigation, might be some sources came to his mind and to examine.
Not question cannot be said.
That question was never put.
All right.
But at PW4, stated Yogi Prasad was present when the statement of PW5 was recorded. Yogi Prasad was present along with
Who
others.
is that Yogi Pradhan? We do not know that in that one Yogi Pradhan is there.
Yogi Pradhan, PW6.
Yogi Pradhan is PW6, but is
is that?
only Yogi Pradhan in that village that we because you have not brought out anything from the evidence
Had a question been
of
there?
PW6 that he was present in the while the statements recording was going on. That thing has not been elicited from the PW6. Vartaman asun se jo next they submitted that what is your that inquest report name not there. Se bisher jaha jaba katha dei debe. Baki delayed receipt of the FIR.
Inquest, my lord has already observed.
No, we'll go by that. You file it. We make a query. See, to embolden ourselves, we make queries. We do not form an opinion by that. We make query just to embolden.
This is ଆମେ जो discussion କରୁଛୁ, don't think that.
I'm not.
ଆମେ ପଚାରୁଛୁ ତାଙ୍କ submission ଗୁଡାକ ଆପଣଙ୍କର ସେଇକୁ reply କରିବେ. But delayed receipt of the FIR ଗୋଟେ ସେ କହୁଛନ୍ତି, ହେଲା? ଆଉ inquest report ରେ ନା ନାହିଁ, dead body challan ରେ ନା ନାହିଁ. And another thing they are raising that why the information which was given by PW4 was not treated as an FIR. Why it was treated as a station diary. Hala? So that also you have to answer. The information has been given that it is a somebody has died and some assault took place.
No, dad, no, you are just hearing sound of bomb.
No, no.
From while passing.
Station diary.
Some people share.
Station diary, Mr. Station diary, just a minute. Station diary entry का exhibit is ना नहीं?
Station diary entry.
Exhibit is ना? कितना number exhibit?
That is exhibit. 11.
Station diary entry टा exhibit है जिब्रा. That is exhibit I think D by B by 1 or कौन? तांको तरफ रो examine है ये जो station diary entry number 510 2891 देखी जन से station diary कौन लिखा है जी? ये बाहर कौन थे ना? Exhibit D by 1 ना B by 1. कौन अन्य
Para 13 because I have not seized.
पढ़े तो
स्टेशन डायरी का सीज है
ना ना मार्क कीजिए पर आप डिफेंस रोड है स्टेशन डायरी एंट्री मार्क कीजिए एग्जिबिट B by 1 देखो
डिफेंस में एक
हाँ
हाँ
सेटा
आपण मार्क करछन
आपण मार्क
यो कोसी सीज
नहीं से नहीं आपण पर मार्क करला सेटा
कौन सेटा लिखा है जी कौन स्टेशन डायरी एंट्री रखवाड़ वाला मार्क कीजिए तो बोल बुलाए दो ना स्टेशन डायरी एंट्री पूरा मेयर स्टेशन डायरी एंट्री वोल्टा पूरा मेयर कितने नंबर था कितने स्टेशन डायरी एंट्री नंबर 510 है बहुत तोड़ गई 510 में बहुत तोड़ गई चलो तोड़ूंगे 510
PW4 question. Which is
हाँ सो 10 रकम रखा है जी
at that time 2 to 4 persons crossed me with analysis of it and regulatory.
Have you got that copy, Mr. Dhon? ये जो अपन मार्क करते एग्जिबिट सेटा बोले C by 1 की D by 1 उड़ अपन की मार्क की
That is a stepend of PW4 also. You had given that stepend.
we just want to see that station diary entry. এটা হচ্ছে সেই occurrence जो PW4 देला जहाँ बेसिस रे स्टेशन डायरी एंट्री कला सेई गोटा को आपनको तरफ माने मार्क की
507
507
830
ସେଇଟା କୋଟା
28
हाँ इधर से हाँ ये गोटा तो मार्क की दियो
Exhibit C.
उदयनाथ करो की at this hour so and so
he's 50
PW4.
अच्छा उदयनाथ करो so and so of came to PS reported that he was returning to his village
B by 1.
so and so and near village so and so he got the information that some persons assaulted Bhagirathi Kaur in the village today evening and
there is
so
in the
and so but
there is tension in the village.
there is tension in the village. Noted the fact in the SD. I along with my staff proceeded to the village. ये आउची information दे पाइले ना नहीं जड़ा अरे
पहले नहीं सीटी अच्छी एलसीआर
टोटल पेज होची 1158 तार 318 पेज को पढ़े सुन 300 से मझी रोटे पेज नंबर दिखा होची 1158 रो 318 नंबर पेज हाँ 318 318 ना अपन देखो तो 507 नंबर टा होची से स्टेशन डायरी एंट्री टा टाइम भी देइछंदी 8:30 बेले एविडेंस भी से गाँ को आसला हठात शुणला कौन बम पड़ा काट किए लोक शुणला से गाँ को आसनी से पड़े उड़ी थाना को पड़े ଏ ଥାନାରେ ଆସିକିନି ଏଇଟା ଦେଇଛି ନା ତାଙ୍କ ସବମିସନ ହଉଛି ଯେ ସେଇଟାକୁ ଟ୍ରିଟ୍ କରାଯାଇଥାନ୍ତା ଆଜ ଏଫଆଇଆର why it was not treated as FIR ତେଣୁ ତା ବିଷୟରେ ଯାହା କହିବା କଥା କହିବେ ଆପଣ vote କରିନିଅ।
Bring it the village. Evidence ର କହୁଛି ସେ ଭାଗୀରଥୀ କରବାସ border ଏହା
ନା ନା ଏଇଠି ବି କହିଛି
ନା ଏଠି କହିଛୁ ତ ଆପଣ ପାଇଲେନି କି ସେ ଷ୍ଟେସନ ଆଇଡେଣ୍ଟିଟା
507
ହଁ 318 ପେଜରେ ଅଛି ବା
ଆଜ୍ଞା
1158 ରୁ 318 ସେଟା ମାର୍କ ହେଇଛି ସାଇଡରେ ମାର୍କିଂ ଅଛି
Exhibit B/1.
B by
B
one.
by 1
ତା ଠିକ
B by 1
এটা exhibit
Speaking to had assaulted him.
tells you that is there.
And there was a problem.
So whether it is Mr. Mahanti, whether it is required that when an information is given that who are the accused persons, how they assaulted, then only the FIR would be registered. And if this sort of information, we can say that some information is given that would not be treated as the FIR on the basis of that station diary entry. So the vague information गोटे आसिला गोटे केस रे जेमती गोटे मर्डर एजेसी कार्ड सुनी कि आसिला जण so the whether the IO is bound to register is the FIR or is to make a station diary entry ता विषय देखिबे
If the reason, the cognizable offense reveals, then it is wrong.
cognizable offense to make out murder पर लिखे
assaulted
In order to ascertain one stationary entry, after the ascertain that things has been done, if they are formally proceeded to spot
एठी
and found the person who was the
some persons assault
some persons assaulted तो
ତେଣୁ ଏଇ ଲାଇନ ଟା ଅଛି it is not that it is
ନାଇଁ
ମାନେ cognizable ଆପଣ କହୁନାହାନ୍ତି ଯେ ଏଟା cognizable ନୁହେଁ ତେଣୁ ସେଇ ଯୋଉ
find
ଲଲିତା
out
case
veracity of the information provided. Once he, on this basis, if the affair would have learned and found something that it is not, then it would have more fatal than the not registering. Because immediately police proceeded this spot and found the persons there, record the statement, oral statement also record. That means there is no
time gap to time
pulpiness
gap
in the mind of the people to implicate something on the other.
Mr. Dhol and we'll come after lunch and hear this further.
Supplementary list, item 1.
Yes.
Some advancing name of the sum of the accused persons is not available in the inquest column number 9. That effect my lord submit 174 1 of the clear. The answer for the request to investigate into and the draw of the report, apparent cause of death, prescribing such wound, what weapons used, manner or object to ascertain whether the person died under suspicious circumstances. It is on the direct evidence. Meet with the death. The omission in the inquest would not be sufficient to the prosecution in doubt. Once there is a direct, and those persons who have signed in the inquest, they are not the eyewitness to the occurrence.
Just a minute. So you will, in your citation, you will give those decisions, that omission of names of the accused persons in that column number 9 of the inquest report is not fatal to
When the
prosecution.
direct evidences
Ah, that's right. Yes.
and the right from the in the very strenuous endeavor made by learned legendary of that time class to try to dislodge all those things, but it could not be elicited from the mouth during cross-examination to disbelieve the entirety of the evidences of the eyewitnesses. So some omission or some discrepancies may be there, but it cannot be take away the entire evidentiary value of the witnesses. Those who have directly implicated the appellants, insofar the appellant assailant parties.
Other appeal is concerned, yes. 170 the 90 get
So the 34 is that my submission is that their involvement in the common intention they have prepared with a meeting of mind to that effect. And the another aspect is raised by the related examination.
PW6.
PW6. The belated is to be examined in the fact and circumstance. There, IO has a in his statement has stated that nobody was available there on this day or thereafter to stated that so even though the 6 was in the belated, but the evidentiary value of other 2 witnesses is not go.
No, he's
Only one.
that argument is advanced only in respect of PW6 because they were promptly examined. This other 2, PW1 and PW5, they were.
And it was not there is no in the cross examination while to the IO, no question was put. Where we got the information, and if at all some development is made in the prosecution, it will be taken away the evidentiary value of other 2 witnesses. So another point was raised by learned senior Mr. Dhal that the 1 and 5 was never disclosed in the presence of 6 as a witness to the occurrence. The scenario is to be said. 1 and 5 was the accompanied with the deceased.
They were at a particular
time.
They were just ahead of the deceased. In one cycle.
In one cycle. So 6 was sitting in the veranda of that in-laws.
His brother-in-law.
Brother-in-law. So in a commission of offense this nature, in a brutal attack is going on, it is not expected that a person will look here and there who are present there to be
on whose veranda and to name the
name. So it is natural, it is normal in course that somebody may witness something, but it is not known to the other witnesses also. But it cannot be said that 6 is not an eyewitness to the occurrence. When the evidence is, some of the evidence is clear and cogent and credible to the evidence is corroborated the evidence of 1 and 5. Vis-a-vis the injury sustained and statement of 8 medical officers have stated. All these injuries, not that 1 or 2 or 5 injuries. Injury are 16 in nature. Weapon offenses are being used. So it cannot be said that the entire story is a concocted story prepared. It is the genesis and grounds has now been disputed at this stage. When at the initial stage in the during course of trial, it was not brought from the, not elicited from the either IO or the other witnesses who were examined that there was no such occurrence. The ill feeling was there. enmity was there. For sometimes there was some reconciliation through village, but that doesn't mean that entire enmity was wiped out from the mind. It will be developed friendship for all times to come. But it may good ground that some friendship will create and likewise in other offenses that to call a some person friendship and take away from isolated place and doing some commission of offense.
No, what you mean to say that absence of the name of PW6 as an eyewitness in the statements of PW1 and 5 is not a ground to disbelieve
Disbelieve
the
the
Presence of
presence of PW6 because he was at a different place and it might not have been noticed by PW1 and 5. That is.
in such a offense, once the one of the his accompanying person being brutally assaulted by a group of people in the deadly weapon, it is not to say who are others there in which places to whom it will be observed, will be adduce them as evidence. In one evidence is sufficient to punish a person in, and that is amounts to also be involved in a credible manner.
Okay.
So one more discrepancy was pointed out that PW6 in his earlier statements had told that he was standing in front of the house of one Hari Pradhan, whereas in the evidence he says that he was standing in the veranda of his own brother-in-law. This is one discrepancy was also pointed out.
But that discrepancy is not attached to the root of the case to disbelieve the entirety. But that place of placement and subsequent placement doesn't brought that these are two different places. That nothing has been brought out from the two different places.
हरि प्रधान रो घर कोठी आउ ये जो तार भेणी घर कोठी छोड़ा के एमिति एते दूर रे जे सेडा टोटली डिफरेंट प्लेसेस
सेटा
created disbelief in the mind of that is totally a concocted story created by the PW6 against having no enmity enemical attitude also been brought out that they are the enemical to the appellants so that he is deposing falsehood against him.
PW6 अच्छा yes.
So mere delay in examination or not paternity possibility of acceptable of implication is there in part of the evidence.
Anything further?
No, that station diary will actually
PW4.
PW4.
That is their submission that
Yeah, move.
the station diary should have been treated as FIR.
Only that.
PW6 तो कहूची मु आसुथिली गाँ को आसुतारो बाटरे दीटा लोक मते कहिले गोटे बम साउंड सुनली बाटरे मते कहिले जे आरो
PW4
हाँ सॉरी 4 PW4 मु सेही टू पळे माने गाँ को भी जाइनी.
So it is a hearsay that can be the eyewitness. He is the hearsay. Then I will
he is not an eyewitness. He is only eyewitness.
Hearsay. He has not observed the entire scenario. So it can be believed
कि
that police have
काहाटू भी काहाटू सुनिची भी कहूनी से खाली कहूची मु क्रॉसिंग before crossing the river I heard the bomb sound number one and from other side of the river at that time 2 to 4% crossed me and they were having conversation that Bhagirathi was murdered. सेती सुनी मु पढ़ली.
So it can be accepted. It can be at best be accepted the hearsay evidence. So as per the police manual, hearsay report.
Hmm.
It is recorded in the station diary.
Yes.
After verification, they found the authenticity and veracity, then it can be recorded as a FIR.
Okay,
So
that's
it cannot be discarded that it can be a initiation of the criminal prosecution to give an indication to the police and hints that what type of offense has committed, the police can also lead to the place. And there the statement has
what is that particular rule? Police manual जो rule कहउचंती
general diary.
नहीं hearsay material गुड़ाक FIR
बाकी general diary
General diary entry
general
ताकि
diary
जो हमें ताकु fast जो station diary को
तार clause टा केते ता rule टा ताड़ा
VII
ओडिशा police rules धरचन तो
police
police rule लो केते number rule टा
chapter VII
chapter
VII
7.
VII मान 7
3 नहीं 3 8
8.
Oh, 8
Triple.
8 VII
143
rule 43
143
कौन कुछ पढ़ो
Dr. Hearsay reports that information of the commission of a cognizable crime which first reaches to the police, whether oral or written, shall be treated as a first information. It may be given by a person acquainted with the facts, directly or hearsay. What is in either case constitute the first information required by law, upon which the investigation of 156 shall be taken up. When hearsay information is crime is given, the station officer shall not wait to record as the first information report the statement of the actual complaint or an eyewitness.
That goes against your submission.
No. The eyewitness, he is not eyewitness. When hearsay information of crime is given,
just stop there.
the station officer shall not wait to record.
Shall not wait to record.
As an first information, the statement of actual complaint or an eyewitness. The actual complaint and
माने hearsay material आसिला माने सी अपेक्षा करिवनी जे नाही ये लोकटार खाली hearsay आनी दउची मु अपेक्षा करिवि गोटे आई विटनेस आसीबो तापरे मु जाई एफआईआर टा रजिस्टर करिवि एटा होची से लाइन टार माने तापरे पढंतु
the vague rumors. A vague rumor shall be distinguished, but here a vague shall be distinguished from the hearsay report. It shall not be reduced in writing or signed.
Vague, you are right. Vague.
So here is the one say here somebody has hearing something from others and it transmit to the police. Then it is recorded in writing. The police is the past duty either to verify the veracity, whether may it lead to the some vague information. Then it would have been caused some other fatal to the prosecution case. The police immediately rushed to the spot within 1 hour, 2 hours.
माने आपण जोटा पढुचन क्षेत्र जणा पडुची what it means to say that vague जदि कोनोसी रिपोर्ट आसिला ताहले it should not be treated as FIR, but जदि hearsay आसिला ताहले hearsay टाकू जणे माने अपेक्षा करिवनी it can be treated as अच्छा so
the police duty cast on the police to verify
to distinguish.
So after that station diary entry, that in recorded that something has happened on the basis of PW4, police rushed to the spot and recorded the oral statement. There the statement, the signature of the PW4 who was giving the first information as well as the PW5 was there. So once the report of the some incident of in criminal act being intimated to the police without any delay at the very in a due promptitude, it cannot be treated that the people's have also being implicated and the genesis and the origin is go away.
Any questions have been put that why you are not treating this station diary entry as FIR?
No.
Why you waited till came to the village and no question?
No question. I will.
What is the distance between the police station and the spot? Must be there
10
in
kilometers.
10 kilometers.
Connecting, well connected pitch road.
Okay. When the station diary was, that is
8:30.
8:30. 8:30 PM na? 8:30. अच्छा, FIR टा केबे receive कला spot रे पहुंचू? 9:30.
Jeep range.
ये जो चप्पल आउ ता घंटा एगुड़ा को स्पॉट रू जबत ही ना कौन जबत होला स्पॉट रू
1 and 2.
हम्म
1 and 2. Remove.
माने सीजर विटनेस सपोर्ट कर चिंता दे
On 9th of July, the wristwatch was seized on production by PW7.
Yeah. Wristwatch and cycle.
Wristwatch on production by PW7, cycle also.
no not from the spot
No.
No, not from this.
Spot.
ସେ ତ ନଥିଲା ସେ ତ
ପ୍ରଶ୍ନ ସେଇଥିପାଇଁ ପଚାରୁ ଯେ
Exhibit 6 is the seizure.
ସ୍ପଟ ରେ ଚପଲ ଡିସିଜ ର ପଡିଗଲା ନା ତା ଚପଲ କି ଘଣ୍ଟା କି ସେ ସାଇକେଲ କି ସେ ଯୋଉ ପରିବା ବେଗ ଆଉ ତା ଛଡା ହଉଛି ରକ୍ତ ଏତିକ ନଥିଲା ବୋଲି that is Mr. Dhol argued that the spot is doubt.
Cycle ପରିବା bag ସହିତ siege ହେଇଛି on production by PW7.
No, that
Yes,
is
yes, that is afterwards.
ମାନେ
On
ମାନେ
9th.
ଯେ ପୋଲିସ
ଯେତେବେଳେ ଗଲେ
ଯେ ମୁଁ ଯଦି ପହଞ୍ଚିଲା ବେଳକୁ ଏଗୁଡାକ ଯଦି
ନଥିଲା।
ଦେଖିଥାନ୍ତି ତାହେଲେ ମୁଁ ସିଜ୍
ହଁ
କରିଥାନ୍ତି
ପୁଲିସ ସେ କଥା କହୁଛି
ହୁଁ
କହୁଛି କୂଅ ମୁଁ ଖୋଜିଲି କୂଅରେ ପାଇଲି ନାହିଁ
ପାଇଲି।
କିନ୍ତୁ circumstances of seizure ରେ ଲେଖା ହେଇଛି exhibit
No,
six
just
ରେ
one of the
ଯେ
witnesses has
କୂଅରୁ
also stated that it was in the well.
ହଁ
Someone has thrown it in the well.
ହଁ
PW5.
PW5. The one of the accused has thrown it to the well.
Not PW5. I don't think PW5.
PW5.
so by the time let us say by 6:30
Six, correct.
PW6.
ହଁ 6:30 ରେ ଓଭର ହେଇଗଲା ଆପଣଙ୍କର ଅକରେନ୍ସ ତାପରେ ସେଇ ଇନଫର୍ମେସନ ତାକୁ ମିଳିଲା ସେ ଆସୁଥିଲା ସେ ପଳେଇଲା ଥାନାକୁ ଥାନା ବାଲା ଆସି ସ୍ପଟ ରେ ପହଞ୍ଚିଲେ ତାପରେ ଇଏ ଓରାଲ ରିପୋର୍ଟ ଦେଲା ତ ଏଇ ଯୋଉ ଟାଇମ ଗ୍ୟାପ ଟା ମିଳୁଛି ଯୋଉ ଲେଟ୍ ଅସ୍ ସେ 6:30 ରୁ ପୋଲିସ ପହଞ୍ଚିବା ପର୍ଯ୍ୟନ୍ତ 3 ଘଣ୍ଟା ଟାଇମ ମିଳୁଛି so whether it is your case that the possibility of removing those things from the spot is probable like cycle but
In order to wipe out the evidences of some of their materials.
ସେମିତି ପାଇଁ କିଛି 201 ର କିଛି ଚାର୍ଜ ନାହିଁ
Charge.
so there is probability possible ଅଛି ଯେ accused
Those
person
who are committed the offense and other persons are prohibited to enter into that place. They might have caused all the disappearance there. Some remove the articles, other things.
one evidence
କାହିଁକି ନା
is
ସେ
coming
ଯୋଉ-
that ସେ ନାଇଁ ପକେଇଦେଲା ସେ ସାଇକେଲ ଟାକୁ ଯୋଉଟା କୁଏରେ ଯୋଉଟା କି ଅବଶ୍ୟ ଆଇଓ କହୁଛି ମୁଁ କିଛି ପାଇଲିନି
PW6 କହିଛି ସେ
କିନ୍ତୁ
ହଁ।
କୂଅରୁ ଯୋଉଟା ସିଜର ଲିଷ୍ଟ ବାହାରିଛି 50 ବା ଯୋଉ ହ୍ୟାଣ୍ଡେଲରେ ଟଙ୍ଗା ଥିଲା
ହଁ ନାଇଁ
Vegetables.
ସାଇକେଲ ସେଟା ତା ବାପା ରଖିଥିଲା ଆଣିଦେଲା ପରା
ନାଇଁ ଗୋଟିଏ କଳା ରଙ୍ଗର ପୁରୁଣା ଆଟଲା
ସେ
ସାଇକେଲ
ସିଜର ଟା ହେଇଛି ତା ବାପାଠୁ ବାପା ହଉଛି PW କେତେ ଗୋଟେ 7 PW7 ତା ସିଜର ଲିଷ୍ଟରେ ଦେଖିଲେ ଲେଖା ହେଇଛି ଯେ ଇଏ ଆଣି ପ୍ରଡ୍ୟୁସ କଲା ବାପା ଆଣିଦେଲା ବାପା କହୁଛି ମତେ ପୋଲିସ ଆଣିଦେଲା ଆଉ ବାକି ହଁ ଚିଫ ରେ କହିଲା କୂଅ ଭିତରୁ ଖୋଜିକିନି ଦେଲା
ସିଜର ଲିଷ୍ଟରେ ସମଥିଙ୍ଗ
some kind of discrepancies are
because he was a man of 1996 occurrence examined after more than 6 to 7 years.
ହଁ
So some sort of things by the human memory is sort
PW2
Something is-
spot ରୁ ଗୋଟେ cycle.
Yeah, it is not the not best.
okay anything else
This is my sum obstruction. If anything will be advanced from there.
Okay, okay.
Okay.
Yes, Mr. Panda.
And substance that entire evidence of eyewitness is cannot be brushed aside.
Okay.
Not for.
Your lordship has been hearing this appeal in extensively.
Hmm.
And my learned senior friends and junior friends have placed materials. I will only ask your lordship to kindly first look at this part.
Hmm. Mr. Panda, you are appearing in which appeal?
I am appearing for appellant number 5 in 190.
ଆଚ୍ଛା ଗୋଟେ କାମ କରନ୍ତୁ ଆପଣ ଯୋଉ
ଇଏ କାହା ପାଇଁ appeal?
ଇଏ କାହା ପାଇଁ ଅଛନ୍ତି ସେଇଟାକୁ କାରଣ 3 ଜଣ ଆଡଭୋକେଟ ଅଛନ୍ତି କମ୍ପୋଜିଟ୍ ରହିଛି ତେଣୁ ବେଟର ହଉଛି ଆsk them for so and so we can write ହଁ କୁହନ୍ତୁ
Now, if your lordship sees this spot map, lordship may kindly look at the right hand top portion, my lords, where that letter N is there.
spot map has been marked as exhibit
Spot map is exhibit 16.
16 बाहर करो yes we got it
Now, if your lordship will see this spot map, the road, main road where the incident has taken place, runs from Godipada to Saranpul,
right
from north to south. Now, these witnesses and deceased were allegedly coming from Godipada and proceeding towards their houses, my lords. That is the prosecution story. And their houses are not on this Nuasai place or at the spot. Now, my lords may look at the spot at the top right hand corner, where that letter N is there. Below that, the house of the deceased has been indicated.
House of the
Deceased.
Top right corner.
right corner
What a river Kusumi, what a lekha it is flowing from. ତା ଉପରେ ଆଜ୍ଞା ଦେଖନ୍ତୁ ହାଉସ ଅଫ ଦ ଡିସିଜ୍ଡ ଭାଗୀରଥୀ କର ଦେଖନ୍ତୁ.
So they are going, it's not that he is going to the house. They were coming on that road. So it's not the case that he was going to his house.
It is their case that they had gone to purchase groceries and were returned.
It may be that after leaving that person, he will come back to the house. That is not the case.
କାହାକୁ ଲିଭିଂ କରିବେ?
ଯେ ଆର ଯେ ତା ସାଙ୍ଗରେ ଯିଏ ଯାଉଥିଲା
ସମସ୍ତେ all of them belong to other Sai Millers, ପୁରୁଣା Sai.
deceased, no, that is, they were going and during that, so.
But the entire prosecution story is that they were returning to their houses
Yes, yes.
in the village. If they are returning to their houses in the absence of any evidence that this is the road which goes towards Puruna Sai Millers, why should they cross the shop of Subala Pradhan?
Should have asked those questions.
Not necessary, Millers. I am only pointing out.
It's a hypothetical.
No, it's not hypothetical. I'll substantiate it, my lords. Why answer? Now, your lordship will mad.
ଆପଣଙ୍କୁ ପଚରାଇବ ଆପଣ ହାଇକୋର୍ଟକୁ ଆସିଲେ ତ ମଙ୍ଗଳବାର କାହିଁ ପଳେଇଲେ
ସେଇଟା ଆଜ୍ଞା ମୁଁ ଉତ୍ତର ଦେବି ଆଜ୍ଞା।
ହଁ ନାଇଁ ନାଇଁ
ଦେଖନ୍ତୁ PW6 ଯୋଉ କହୁଛି from the house of his brother-in-law Abhijana, that is also not
No,
indicated.
that
in
is
this
already
part.
argued and you have pointed out.
Yeah,
That not
that is that is that, yes.
That is also not
That is
pointed out.
That is argued.
Yeah.
So this is what I want to show from this spot map. The other aspect your lordship may see. Now look at the accused statement of the accused appellants. I will draw your lordship's attention to the statement of this Durjodhana for whom I am appealing. Now, how casually the questions have been put, and I will again demonstrate how casually the learned session judge has written those questions.
What is that? Accused statement.
Yeah.
କାହାର?
ଦୁର୍ଯ୍ୟୋଧନର ଦେଖନ୍ତୁ
Page 108. 108.
108. 108.
ଫାର୍ଷ୍ଟ କ୍ୱେଶ୍ଚନ ଟା ଦେଖନ୍ତୁ it transpires from evidence of PWs 1, 5 and 6 that on 2891 the PWs
1 and
1 and 5.
1 and 5 along with deceased Bhagirathi Kaura had been to Godipada and they returned to the village in the evening at 6 p.m. What do you say? And your lordship may note the correction made in the second line. Not that he has done it without application of mind. He has corrected 2 to read as 5. Next question. They had been to Godipada in separate cycles, and while they were returning to village, PWs 1 and 5 were coming in one cycle, and the deceased was following them. What do you say? Second question, your lordship may know. There again, my lords, there is a correction. 2 has been corrected to 5. Third question now, my lords may see. Near the shop of Subala, it was found that you, along with other accused, had gathered there. And when PWs 1 and 5 and the deceased Bhagirathi passed through you, accused Ronko Nayak suddenly dealt a farsa blow on the back of Bhagirathi, as a result of which he started running by throwing his cycle there. Your lordship may note this. This is a question that has been put to me. Then the next question, my lords may see. You, along with others, chased after Bhagirathi and surrounded him at a little distance. And as he could not proceed further, and thereafter the accused Ronko having dealt a farsa blow on his person, he fell down. What do you say? Where is this evidence, my lord? Then, my lords may see the next question. After his falling down, you, along with other accused persons, assaulted him by means of different kinds of sharp cutting weapons, holding by him on different parts of his body, as a result of which he died at the spot. What do you say? This is the only relevant question, my lords, which in my opinion is the question that has been put to this accused, my lord. And the
Who is your accused?
Duryodhana, Kalu alias Duryodhana.
Just a minute. So you are appearing for Kalu alias Duryodhan.
Yeah.
appellant number 5.
Who is appellant number 5 in that 193?
Yeah. ତାପରେ ଦେଖନ୍ତୁ question 6. While committing such crime, you had also thrown the bombs at the spot to prevent the coming of other persons there to rescue the accused, deceased. What do you say? Where is this evidence, my lord? And now look at the star question, question number 7. What is written? The PW2 lodged an oral report to the police on their arrival at the village on the same day night, and the FIR is exhibit 9. Where was PW2, my lords? Is he the informant in this case? And does exhibit 9 show anywhere that it has been scribed by PW2 or lodged by PW2? And then your lordship may see the next question. During investigation, the police seized incriminating articles like remnants of bombs, wristwatch, chappal, blood-stained earth, blood-stained clothing of the deceased, etc., and prepared different seizure lists. What do you say? Is this how, my lord, 313 statements are to be, questions are to be put? What does this accused know, my lord, about? What will he answer about these questions, my lords? And it is not that somebody, novice has done this. I know the judge, my lords, a very respected judge. from where those articles were recovered, how they are inculpatory. Then, my lords, question 9, that is relating to the postmortem doctor. And then, cause of death is due to hemorrhagic shock as a result of multiple injuries by sharp weapons. Has he anywhere said that it is one of those injuries? You are the author of those injuries. And you have heard the accused persons, what more you have to say? The only culpable question that has been put, my lords, is question number 4. I'm sorry, question number 5. That I, along with other accused persons, assaulted him by means of different kinds of sharp cutting weapons. Now, if question number 3 is accepted, that I, along with other accused persons, had gathered there, what is this? What does it make out? Does it make out a case of a case under section 149 IPC, or is it a case under section 34 of the IPC?
No, it's not only that assembly part, Mr. Panda. After stating that in the assault part also, you have been implicated.
Yes, that is the only question I am saying. Question number 5 is the only relevant question.
So the witness
You, along with other accused persons, assaulted him by means of different kinds of weapons. Now, if this is the relevant question, now let us see the cross-examination of the doctor. What the doctor has stated. PW8. After that, I will lead your lordships to the evidence of the so-called eyewitnesses, who are said to be sterling witnesses by my learned friend. So, page 168 of the paper, PW8.
There are as many as 12.
He has noted injuries, my lords, firstly on the arms, then on the head, then on the back, then on both legs, my lords. He has noted incised injuries. They are all on the limbs, on the head, on the back, on the left leg, and on the right leg, my lords. And he says that the cause of death is due to hemorrhagic shock as a result of multiple injuries by sharp weapons.
Right.
Now, where are these injuries, my lords, and what is the size of the injuries, and what are the depths of the injuries? Now, none of these injuries, my lords, he has anywhere said, my lords, that these injuries are on particular portions wherein there has been some cutting of the vessels underlying the injuries which has resulted in hemorrhage. This is a postmortem report by a doctor who has simply described the injuries without saying, my lords, what is the scope and aspect of the injuries. And he says cause of death is due to hemorrhagic shock. Then what he says is, at page 170, after 2 lines, all the aforesaid injuries are dangerous to the life of the deceased. Farsa and Katari and lathis are deadly weapons. Injuries on the head are on the vital part of the body. Injuries are sufficient in ordinary course to cause the death of a person. Farsa and Katari are sharp cutting weapons. The police produced one Katari, one sickle, one farsa, and a tangi before me, made a query that if the injuries caused on the person of the deceased can be possible with those weapons, and I opined the same in positive, subject to objection. This is my report, marked Exhibit 12. Then, my lords, may kindly see the next page, what is. Head injuries on the deceased were sufficient to cause the death of a person. Now, what are the head injuries, my lords? The head injuries, as he has noted at page 169, are 3 injuries. The first is an incised wound, 3 inch into ½ inch into scalp depth. It doesn't go beyond the scalp. In an oblique direction behind the left ear caused by a sharp weapon. The second injury is an incised wound, 4 inch into 1 inch into scalp depth behind the right ear in an oblique direction by sharp weapon. And the next injury is an incised wound, 9 inch into 3 inch into 3 inch, extending from the right angle of the mouth to the left mastoid process. That is on the jaw, my lords. And all muscles and tissues are divided by sharp weapons. Underlying injuries, my lords, are not noted. The sum and substance of my argument is this, that the doctor's opinion that the head injuries were sufficient to cause death of a person, what underlying injuries did he found to give this opinion that the head injuries were sufficient?
What's the question put to the doctor here?
The question put in chief is that the head injuries on the deceased were sufficient to cause death of a person. The answer is this. The question must be where the head injuries sufficient to cause death. The entire injury report does not show, my lords, what
No,
underlying.
one answer he has given as has been put in the cross-examination that individual.
I am coming to that, my lords. We'll come to the cross-examination. Your lordship may just bear with me for some time. I am a little slow, my lords. I am a slightly slow counsel, my lords.
Thank you. Thank you.
I take some time, my lords. to pleasure.
Come slowly.
Yes, my lords.
We'll wait.
Now,
We'll wait
what he
till you
says in
complete.
cross-examination, my lords, we see the first answer.
Yes.
All injuries were simple in nature. There was no fracture of any bone. Cumulative effect of all the 16 injuries are the cause of. Individually, injury cannot be the cause of death. Then, my lords may see what he says about the injuries. In the next paragraph, he omits, my lords, any injury by a bhusa or a bhala, because he says that blow by a bhusa or a bhala will produce a punctured wound. And he found no punctured wound on the body of the deceased. And none of the injuries had been caused by a bhusa or a bhala. Then he says at paragraph 4 that the depths of each injury was the same, my lords. And he says, the last line of paragraph 4, it can be inferred that the injuries were caused by some sharp cutting weapon having a straight blade. Then it has been put to him and he has answered, in a farsa the blade is not straight. He has said none of the injuries can be caused by a sickle. So also either by bhusa or farsa. These injuries can be caused by a tangi where the blades are straight. If the blade of the kotari is straight, aforesaid injuries can be caused. Blades of the farsa throughout is not straight.
Route is not?
Straight.
Ah.
And in case of farsa injury, there would be a tail in both ends of the injury. I had not found any such tail in any of the injuries. This is the opinion of the doctor. Now, your lordship may kindly look at page 197 of the paper. 195. Exhibit 17, that is the forwarding report of the exhibits which were sent for forensic examination. There, my lords, apart from a bamboo lathi stained by blood, a koturi seized from the house of Subala, a sickle, a farsa, 2 axes, another sickle, and a bhusa, they were all forwarded, my lords, for examination.
Where it is? Kindly come. Again, I am
Yes,
slow.
page 195.
190. Kind. Wait. I am also slow.
Yes, my lords, we should be slow in all these aspects. These are after all murder cases.
We have been hearing this matter since last 2 days, sir.
Lords, when I began practice, my lords, one criminal appeal will take a month.
We'll go as slow as you
Right, my
possible.
lords, we should. Now look at serial number 3, my lords.
Wait. Serial number 3 of the exhibits.
Yes, exhibit 17.
And we take it to exhibit number 3, serial number 3. Three, serial number 3.
3 is the bamboo lathi stained with blood. Carry hell out of bamboo lathi.
Forwarding report, see. Forwarding report. page 195.
Already report.
There is 195, sir. 195. What is that?
195.
195. Put yes. Yes. Proceed.
Serial 3, bamboo lathi stained with blood, seized by the IOSI PK Rautray on 28/91 during investigation. Serial 4 hela ditto. So it has also been seized on 28 during investigation from the spot. ତାପରେ ଦେଖନ୍ତୁ କଟୁରୀ serial 5 seized by SI so and so on 28/29/91 night from the house of accused Subala, followed by one sickle at serial 6, followed by a farsa at serial 7, 2 axes at serials 8 and 9, a sickle at serial 10, and a bhusa at serial 11. All of them have been seized from the house of accused Subala in the night of 28/29/91. And the questions are whether they contain blood or not, whether it's of human origin or not, and if they contain human blood, then what group is it? And besides, whether the blood detected from serial 3 to 11 tallies with blood detected from serial 1, 2, and 12. 1 and 2 millards are the wearing apparels of the deceased. 12 is the blood-stained soil seized from the spot. Now at 197 millards, the report, results of the examination come. Exhibit 18. That is from the director and chemical examiner to the SDJM Nayagarh. So he says the parcel contained a full pant marked as A shirt marked as B, 2 bamboo lathis marked as C and D, then katuri, sickle, farsa, axis, bhusa marked as E, F, G, H, I, J, K. Soil is L, sample soil is M. Now, on exhibits A and B, millards, human origin, bloodstains are of human origin, grouping, no opinion. Similarly, on the bamboo lathi C and D, bloodstains are of human origin and grouping, no opinion. On the next page at 199, what was seized from the house of Subala? Katuri E, no blood. Sickle F, no blood. Farsa G, no blood. Axe H, no blood. Axe I, no blood. Sickle J, no blood. Bhusa K, blood, too small amount. Then soil, blood, deep, human, no opinion because unstained control is not available. So except finding of small amount of blood on the bhusa, which PW8 discounts as having been used, none of the other weapons seized from the house of Subala found to contain any blood, whether human or of any other origin. And the forensic report is at exhibit 19 at page 199. That also shows that in the shirt, full pant, and in the bamboo lathis, saline extract of bamboo lathis, there is no opinion as regards the human blood group with the remarks quantity insufficient. Now, these scissors, who are the witnesses to these scissors? Now, so far as blood-stained earth and sample earth are concerned, the witness to scissor is PW1. Page 3, paragraph 4 of his examination.
PW?
1. Page 140 of the paper book, paragraph 4, examination entry. He speaks of scissor of bloodstained earth, sample earth, Hawaii chappal, a wristwatch from the spot, prepares scissor list, marked as Exhibit 1. And he is also witness to seizure of 2 bamboo lathis having kina on the top and stained with blood-stained marks. From front of the house of Kartika Pradhan, he says at paragraph 6. Now, the scissor list for those bamboo lathis is Exhibit 2. His signature is Exhibit 2/1. Kartika Pradhan has not been examined. Now, the next witness to the scissor needles of the weapons so far as seizure of bombs is concerned, PW3 Bhagavata is the witness to seizure of 2 live bombs. And for the arms and ammunition which were seized, who is this witness? You will not see me. He is PW6.
Some earth, some blood stand out, 1 chapel, and what else? PW6. PW6.
So far as the seizure of weapons, Milords, PW3. Paragraph 2. Page 147 of the paper. Paragraph 2, the last line. He says,
They shot the house of accused Subara Pradhan and recovered 1 katti, 1 bossa,
He says that on the day when Bhagirathi died, police came to my village, called me from my house at about 9 p.m. They took me to the village and found 2 live bombs lying in front of the house of Kirtan. They seized the same and prepared a Caesar list, took my signature thereon. They searched the house of accused Subala and recovered a kati, a bhusa having a bamboo handle, 2 sickles, a farsa, and seized the same. They prepared a Caesar list and took my signature thereon. The Caesar list is Exhibit 7 and signature is 7 by 1. Then he says that the police searched the house of accused Danda Pradhan and recovered 1 thenga bamboo and seized the same under Caesar list Exhibit 8 and took my signature thereon, which is Exhibit 8 by 1. This witness, my lords, who is the witness to Caesar's file, Exhibit 7 and 8, he does not speak about the access which were allegedly seized inside. And what the IO says about the Caesar, that I am placing.
Page 178, para 12.
My lords, may kindly look at page 175. From 174, the Caesars begin. Paragraph 2. Page 174. Shall I place?
Yes, yes.
Then I visited the spot. I seized some bloodstained earth, sample earth, an HMT wristwatch of the deceased Bhagirathi, and 1 Hawaii chappal from the spot in front of the house of Krishna Pradhan. I prepared the Caesar list in presence of witnesses. Exhibit 1 by 3 is my signature in the Caesar list. MO1 is the said wristwatch seized by me at the spot. MO2 is the Hawaii chappal. I seized 2 bamboo lathis having bloodstains from the spot in front of the house of Kartika. I prepared the Caesar list at the spot in presence of witnesses. Exhibit 2 is that Caesar list and 2 by 3 is my signature. I also seized 2 unexploded bombs near the spot in front of the house of Kirtan in presence of witnesses. I prepared the Caesar list Exhibit 3 and Exhibit 3 by 3 is my signature. MOs 3 and 4 are the bamboo lathis seized by me under Caesar list Exhibit 2. I seized remnants of exploded bombs in front of the house of somebody near the spot in presence of the witnesses and prepared Caesar list Exhibit 4. 4 by 3 is my signature. Then he says in the next paragraph, on 28/29/691, I am placing the second sentence. At 1:30 a.m., I searched the house of accused Subala in presence of witnesses and recovered a kotari having bloodstains. Your lordship may mark. A kotari having bloodstains, a da, a farsa with 2 kuradis with wooden handle, a bhusa having bamboo handle, another sickle, and seized those weapons in presence of the witnesses. I prepared the Caesar list Exhibit 7. 7 by 3 is my signature. MO6 is the farsa, 7 and 8 are the kuradis, 9 is the kotari, 10 is 2 sickles, seized by me under Exhibit 7. Can I read, sir? This is the bhusa MO5, seized from the house of Subala under the Caesar list Exhibit 7. I also seized a bamboo lathi from the house of Dondu on that night in presence of the witnesses. I prepared Caesar list Exhibit 8 and Exhibit 8 by 3 is my signature. Now, my lords, kindly see Exhibit 7, the Caesar list. Who are the witnesses to Exhibit 7? Exhibit 7. Now, Exhibit 7, Millards, is the seizure list from the house of accused Subal Pradhan, son of Hajari Pradhan of village Sanagorada. The witnesses are Prafulla Kumar Kara, son of Baidyanath Kara, that is the informant. Bhagavata Pradhan, son of Kaipalya Pradhan. Prafulla Kara is PW6. Bhagavata is, I'm sorry, PW5. And Bhagavata is PW3.
3.
Now, what has been seized? Gotiye Koturi, Gotiye Da, Gotiye Farsa, Gotiye Duiti Kuradi Kathavento Thai, Gotiye Bhusa Bouncevento Thai Lombo Ete, Gotiye Da. आइयो कहला करी कि ब्लड स्टेन्ड सीज कला बोली ता सीजर लिस्ट रे आया लेकिन नहीं करी कि रक्त लगा कटुरी यही होची एविडेंस आया जोटा रेकॉर्ड हिची स्टर्लिंग एविडेंस आया सर्कमस्टांसेस ऑफ सीजर कौन उपरोक्त मुकदमा रे आसामी माने सुबल प्रधान रो घर आसामी सुबल प्रधान घर खानतलास बेले उपरोक्त अस्त्र मान पाया जिबारु एवं सेथिरे रक्त लागिथिबार अनुमान करा जाई घटना रे गुडक व्यवहार करा जाईथिबार संदेह करी साक्षी सामने रे जबत करागला योर लॉर्डशिप में नोट दी टू वर्ड्स रक्त लागिथिबार अनुमान करा जाई एगुडिक घटना रे व्यवहार करा जाईथिबार संदेह करी जबत करागला आ विटनेस किया आज्ञा गोटे हला आई विटनेस आ गोटे हला PW3 जे कि देखिछि आज्ञा सब तो आज्ञा लाइक माय लर्नड फ्रेंड सेड मर्डर सब जिनस देखि हबनी किंतु से देखिला कहला एगुडा सब रक्त लगा सुबल घरु बाहरछि तेणु संदेह आ अनुमान ये होची प्रोसिक्यूशन रो केस ताकू कोठी रखेला पुलिस ऐसे किछि कहला नहीं पठेला पर्यंत कोठी थिला भाग्य बोला या तादर पारा रक्त कि अन्य कौन रक्त लागी
पठेला तो थॉमस पड़े इनिशिया के बयान में पठेছে अठेछि चौक एक कैलेंडर सीजन
से जानी सुनी कि पठेछि ग्रुपिंग ता आसीबो नै
6 मास पर आयोग जो पठे
बाद में कुछ पठे नहीं कौन बाद में
बार देख पैराग्राफ 170
178
आगुरु 177 जो कहिছে कि पठेछि पारा पेज 177 रो जो देखंतु पारा 8
PW9
नहीं पारा 7 टाको देखंतु ऊपर on 8/10/91 I produced the Kotari, Sikil, Harsa and Tangi and Bhusa before the MO who conducted the PM examination, making query regarding the possibility of the injuries on the dead body by these weapons. This is the query 12/1. On 10/10/91 I produced the material objects, that is weapons of offense, before the SDGM so-and-so for sending it to SFSL, and they were forwarded via Exhibit 17. On 19/10, I submitted charge sheet. Exhibit 18 is the report of the chemical examiner. Exhibit 19 is the injury report of the serologist. In cross-examination, my lord may see what he says at paragraph 11. I have no personal knowledge about ownership of the MO seized, but I ascertained their ownership from witnesses examined by me during course of investigation. Then para 12, I have not seen the wristwatch MO1 or the cycle seized by me on 9/7/91 prior to their seizure. MOs like 3 to 11, 12, that is bamboo lathi, bhusa, farsa, kuradi, Kotari and Da are commonly available in every house in that area. I have not sent any of the MOs, particularly MOs 3 to 11 to the district science laboratory to ascertain if there is bloodstained marks on those weapons. The witness volunteers and says that there is no such provision to send to district science laboratory. This, my lords, is again something which strikes me every time, that presiding officers of every court, my lords, they add these things, witness volunteers. Then what is the purpose of my cross-examination? If all these are to be recorded, the bloodstained mark found on those weapons were suspected to the bloodstained mark. I suspected so as they were seized after the occurrence. So what is the basis of his suspension? Because he has seized them after the occurrence, he suspected that they were bloodstained marks. And the serologist report shows no blood stains. So mar bhandaria ko mar. Pick up some weapons, say that we suspect they were bloodstained. Amar anuman re hitla.
Used.
ତେଣୁ ସେ ୟୁଜ୍ ହେଇଥାଉ ନ ହେଇଥାଉ, since there is recovery, these people, my lords, are the aggressors and they are the culprits. Now, my lords, may look at paragraph 13 of the IO's cross-examination. I have not sent the SD entry number 507 dated 28/6/91. I have not seized, which was made on the report of Udayanath Karo, PW4. That SD entry disclosed that some persons, bracketed not named, assaulted Bhagirathi Karo in the village in the evening. I recorded the oral report of Prafulla Karo into writing in front of the house of Krishna Pradhan of village Sanagoroda, Nuasai. When I reduced into writing the oral report of Prafulla, by then one Udayanath Karo was present. This is this witness to the inquest, and PW4, who has gone to the police station, is the author of the information which led to the station diary being made, and is also a witness to the inquest. I have not mentioned if any other persons were present there or not, but many persons were present when Prafulla gave his oral report to me. Prafulla gave his statement openly and to the hearing of others. Immediately after recording FIR, I examined Udayanatha, Golaka at that very place. At that time, I wanted to examine some more eyewitnesses, but none were available for the examination. I am not sure if those persons were present, and they did not volunteer at that time to give their statement, and on subsequent occasion they came, offered their statement to me. At that time, I tried my best to examine eyewitnesses, but they were not available to me for examination. I recorded the statement of Udayanath Karo PW4 first, then statement of Prafulla Karo 5, thereafter statement of Golaka. Even after examining those three witnesses, they did not disclose to me if there is any other eyewitness to the occurrence. After I recorded their statement, I made an attempt to know and examine other persons who had seen the occurrence, but nobody came forward to give the statement. This I placed because my learned friend argued before your lordship that the witnesses to the inquest, they were not eyewitnesses. So their non-naming is of no consequence. Now, if Udayanath Karo, who is a witness, was present when the statements of the witnesses were recorded, what prevented them from saying so in the inquest report? Inquest report lecture kona miscreants mane marichen. Tama gaଁ लोक तुम तंग चिन्ही ना miscreants mane marichen. दुर्बृत्त mane marichen. ଆଉ ଗୋଟେ ଷ୍ଟର୍ଲିଂ ୱିଟନେସ୍ ଆଜ୍ଞା ହେଲେ ଫକୀର କର PW7.
166.
Page 166, my lords, may come please. This is Bhagirathi was my son. He died in 1991. He was murdered in village Sanagora. Police during the investigation recovered a cycle from a well, my lords may mark, and seized the same in my presence and prepared seizure list by exhibit 6 and took my signature thereon. This is my signature marked exhibit 6/2. Police gave the cycle in my Jima. I executed a Jimanama by exhibit 10 and my signature is 10/1. Cross-examination. The day
Relevant paragraph is 4, Mr.
Paragraph 4. I cannot say from where the police recovered the cycle. Police gave the cycle in my Jima at Sanagorda village. By then it was 11 a.m. I had been to the village on the call of the police. And this seizure list exhibit 6 is dated 9/7 at 12:30 p.m. Place of seizure at village Sanagoroda. Now let's look at that seizure list.
No, that is, he also admits that there is some kind of discrepancies there. Because the IO says that it was handed over to him in that seizure list by this man, PW7. Into PW7 कौची मत्ते आनी किन्हे hand over कला आउ तादेर लिखा इची वो रू बाहरला आउ वो बाहरला बोली से जानी नहीं PW7 रो evidence होची मु जानी नहीं कोठु आयो मिलला so
ଏଥିରେ ବି ଆଜ୍ଞା ସାକ୍ଷୀ ହେଲେ କିଏ ନା ସେଇ ଦି ଜଣ ଏ ଯୋଉ ଭାଗବତ ପ୍ରଧାନ ସନ୍ ଅଫ କୈବଲ୍ୟ ଆଉ ଗୋଟେ ହେଲା ବାମନ ବିଶ୍ୱାଳ ସନ୍ ଅଫ ଚନ୍ଦ୍ରମଣି. Bamana has not been examined. Bhagavata is PW. Article seized ହେଲା ଗୋଟିଏ କଳା ରଙ୍ଗର ପୁରୁଣା Atlas cycle number 83. The witnesses are 2 and 3. I'm placing the circumstance. Article seized ଗୋଟିଏ କଳା ରଙ୍ଗର ପୁରୁଣା Atlas cycle number 80. ହ୍ୟାଣ୍ଡେଲ ରେ ଗୋଟିଏ କଳା କନା ବେଗ ରେ କିଛି ପଚା ଆଳୁ ପଚା ଉଲି ରସୁଣ ଅଦା ବିସ୍କୁଟ ପାଳୁଅ ମିକ୍ସଚର ପୋଟଳ ତେଲ ଶିଶି ପ୍ରଭୃତି ଥାଏ. Circumstances of seizure ହେଲା ଉପରୋକ୍ତ ମକଦ୍ଦମାରେ ମୁଦାଲା ମାନେ ଘଟଣା ପରେ ମୁତଫା ଭାଗୀରଥୀ କରଙ୍କର ସାଇକେଲଟିକୁ ନେଇ ଘଟଣାସ୍ଥଳ ନିକଟରେ ଥିବା କୂପ ଭିତରେ ପକାଇ ଦେଇଥିବାରୁ ଏବଂ ତାହା ଉଦ୍ଧାର କରାଯାଇ ଫକୀର କର ଦାଖଲ ଦେବାରେ ସାକ୍ଷୀମାନଙ୍କ ଉପସ୍ଥିତିରେ ସାକ୍ଷ୍ୟ ପ୍ରମାଣ ନିମନ୍ତେ ଜବତ କରାଗଲା. ଏଠି ଆଜ୍ଞା ଆଇଓକୁ ଫେର ଦେଖନ୍ତୁ ସେ ଯୋଉ ସିଜର କଥା କହିଛି ୱେଲ କଥା କହିଛି.
That is still that the discrepancies are there.
ସାଇକେଲ ଆଜ୍ଞା ତା ସାଙ୍ଗରେ ଯୋଉ
ସାଇକେଲ ସାଙ୍ଗରେ ଯାହା ଆଣିଥିଲା ତାକୁ ରଖିଛନ୍ତି
କୂଅରେ ପଡିଲା ପରେ ବ୍ୟାଗ ଭିତରେ
ଦମକଳ ବାଲାଙ୍କୁ ଆଣି ପୁରେଇକିନି ଆଳୁ ଆଉ ସେଗୁଡା ସବୁ ବାହାର କରିଥିଲେ.
The article purchased by him is started.
There's some discrepancies. He is now harping on the evidence of these 3 eyewitnesses. He has stated that there are some discrepancies. Say jo cycle kotha kouchanti.
That those discrepancies are there. We have been telling right from the beginning.
They are all material discrepancies.
Yes, all right. Then you come to that.
Yes.
What are the material discrepancies which goes to the root of the case?
Now, my lords may kindly look at the evidence of PW1.
One thing, just Mr. Panda, just one pause for a moment. Mr. Mahathi, as for this PM doctor, What are the weapons which have been excluded from the assault? Have you marked it? See the cross-examination.
Something is, something
Just see the cross-examination. 4 weapons have been excluded from the assault. Look at page number 171, paragraph number 3.
Right.
First paragraph number 3, last line. None of the injuries had been caused by Bussa or Bhala. Dita weapon Golad.
That only I was trying to bring, which Mr. Panda, you did not come.
And
I wanted to point out that.
I had placed that.
You never placed.
Yes.
You did not come.
I did.
You did not come.
you should refer to the chief examination of these witnesses vis-a-vis this evidence.
Yes.
And you see the
It has to
PW paragraph number 5
Yes.
of that cross-examination of that PM. In Farsa, the
Blade
blade
is
is
not-
straight and none of the injuries can be caused by sickle, Bussa, Farsa. So, sickle gola, Farsa
Bussa
gola,
gola.
Bussa gola, Bhala gola. Now you come to the evidence of your eyewitnesses. Whatever the assault has been made, that is
Kati
stated
gola.
by the witnesses, जो माने मारिचंती actual assault रे, सोडा का सबू एई चारिटा weapon को
Aye.
you come to one by one. You come to PW
One rule.
one to the front. One रे आसो तो आपण रंको कोउथरे मारला देखो कोन आपण एविडेंस हाता राइट कम टू आउ तापरे पैराग्राफ 3 रे देखो
दुर्योधन फारसा
सब गुडा गला फारसा
फारसा काटी
पैराग्राफ 3 रे तापरे
ସୁବଳ କାଟିରେ
सुबल काटी
ମାଧବ
but
ଭାଇ
no don't go so fast. You are telling that you are going slow.
I am slow.
सुबल सेठी ता ऊपर लाइन ने कहला फारसा ब्लो डेल्ट
ଆଜ୍ଞା
किंतु एठी कोजी सुबल वाज होल्डिंग ए काती.
ଆଜ୍ଞା
Again you see that Madhava was holding Bhali Bhusa. Right?
ଆଜ୍ଞା
Bhali Bhusa excluded, Farsa excluded. Then now you come to the evidence of PW5 also. See this evidence.
Properly at page 153.
53. First Ronko, Farsa,
ଆଜ୍ଞା
that is excluded. Then paragraph 4 रे सब कोउथरे मारले देखो.
ସୁବଳ ହୋଲ୍ଡିଂ ଏ କାତି
नहीं मारिले जोटा हाँ.
ହଁ ସୁବଳ ହୋଲ୍ଡିଂ ଏ କାତି
हम्म
ଦଣ୍ଡୁ ହୋଲ୍ଡିଂ ଏ ଫାର୍ସା
हम्म
କାଳୁ ହୋଲ୍ଡିଂ ଏ ଫାର୍ସା
हम्म
ମାଧବ ହୋଲ୍ଡିଂ ଏ ଭାଲି ଭୂଷା
हम्म.
they surrounded Bhagirathi and assaulted by means of those weapons.
Except Kati, as per the evidence of this doctor, all the weapons have been excluded from the assault part. Again, you come to PW6.
6 ala page 162. Para
You
3.
see the weapons which they are holding. That is 162 ର
Para 3.
Tangi is there.
ନାଇଁ ନାଇଁ ତା ଉପରୁ ଅଛି ତା ଉପରୁ ଟିକେ ଅଛି
ଉପରେ କଣ ଧରିକି ବସିଥିଲେ
କଣ ଧରିକି?
ଫାର୍ଷ୍ଟ ଟପ୍ ରେ ସୁବଳ was holding କାତି
ହୁଁ
ମାଧବ was holding ଭାଲିକମ୍ ଭୂଷା
ହୁଁ
ରଙ୍କ holding a ଫାର୍ସା
କାଳୁ
ଦୁର୍ଯ୍ୟୋଧନ holding a ଫାର୍ସା ବିଧୁଭୂଷଣ was holding a ଫାର୍ସା
ହୁଁ.
and standing in front of the shop of
assault start ହେଲା assault ଦେଖନ୍ତୁ.
assault start ହେଲା para 3 ରେ
ହୁଁ.
accused Ronko dealt a farsa blow which fell on his left ear from his backside.
Right. ତାପରେ
In
ଦେଖନ୍ତୁ
this
sir.
blow, on the falling down, accused Abhi, Madu, Ladu Kishora,
ହୁଁ
Kishora Pradhan, Ronko, Duryodhana,
ହୁଁ
Subala, Madhava, Vidhubhusana
ହୁଁ.
assaulted him indiscriminately with their
ସେ ଉପରେ
respective.
କହିଛି ସେମାନେ କଣ
ଆଜ୍ଞା.
କଣ ଧରିଥିଲେ.
ଆଜ୍ଞା.
ତେଣୁ ତା ଯୋଉ କେତେ ଗୁଡାକ ନାଁ ନାହିଁ ସେଗୁଡାକ କାଟିଦେଲେ how do you reconcile it? That would be the
that has
objection.
been assassinately dealt with in that
हाँ,
judgment.
कारण हाँ नहीं you should show us कारण you see even though in the chief examination he has stated, this doctor has stated that the IO produced, you come to page number 170.
Right.
170 ର last 5 lines କୁ ଆସନ୍ତୁ. Police produced Kottari, sickle, Parsa and one tangi before me made a query. If the injuries are possible, I answered in positive. Now, just a contrary statement has been given. ताधियोरु आपनकर फार्सा एक्सक्लूड करागला, सिकल एक्सक्लूड करागला, बाकी दीटा रहिला कटारी आउ टांगी. कटारी के यूज करछन्ती बेली एविडेंस नाही. तो एटा को केमती डील करछन्ती जे जदी चारिटा वेपन आपनकर एक्सक्लूड ही जाउची, which the eyewitnesses have stated have been used. And if you say that there is a positive statement, then what prevented you, your public prosecutor, to show those weapons which are marked through the IO? It could have been shown to the this doctor that these were the weapons which were produced before you, and looking at these weapons you have given the opinion. Hala? Tenu apan pauna ji completely gote contrary se evidence deichi beli.
That result, once the injury has been described, sustained, and thereafter the doctor has himself recited something which has now created a doubt in the mind of.
You had got the scope to re-examine the doctor.
No. Here is the case. That part has been succinctly observed by the Learned Trial Court in para 31, and for which
Chief examination, just a plain and simple question. Chief examination at least दीटा वेपन कहिछि, चारटा तो कहिछि, जो दीटा वेपन ने से कहिछि पॉसिबल हबो बोली, ठीक गोटे कंट्रारी एविडेंस आनिकिन दोछि क्रॉस एग्जामिनेशन जे फारसा रे कोनोसी इंजुरी हेई परिबो नाही, सिकल रे कोनोसी एग्जामिनेशन हेई परिबो नाही. अपार्ट फ्रॉम दैट हाली आ गुसा तो पब्लिक प्रोसिक्यूटर रो ड्यूटी थिला ना नाही, ताको री एग्जामिन करिकिन पचरे आज्ञा चीफ रे कोन एक कथा कहले जे दीटा वेपन रे पारिबो, एटा कोन एमती कहले, व्हाट इज योर यू शुड हैव क्लैरिफिकेशन माइथांदा आ केमती डील करछि दैट कारण आपनकर वेपन ऑफ असॉल्ट होछि मेनली ए जो वेपन गुडा सिकल डाउ छाडी दियंतु फारसा भाली भूसा हला. एवं से डॉक्टर हैज असाइन्ड द रीजन. इट्स नॉट दैट इज ए भेग स्टेटमेंट. से कहउचंती जे भूसा रे कोन पई हेई परिबोनी, भाला रे कोन पई हेई पन, से कारण दउचंती जे ए ये गुड़ाक पंक्चर्ड वुंड होता. तो आप क्लारिफाई कर दे था जदि भालाटा को ए टाइप रो यूज कराई था कि भूसाटा को एमती यूज कराई था ताहले इनसाइज वुंड पॉसिबल कि नहीं.
This is answered by the trial court in paragraph 21.
No,
and he has disbelieved Pidurait. That I will not rely upon the evidence of Pidurait because he is giving.
Doctor's evidence has been disbelieved.
Right.
Rather the
Learned Trial Court with that observation report to matter of the government for taking action against that doctor. Because of that result, in such a heinous crime, and when direct evidences are there, the doctor himself found the 16 injuries are different parts. Once he has stated that the injuries are in cumulative study of read of these injuries can cause death, then subsequently resigning his statement is really fatal. Then no prosecution can establish if this type of evidence can be released.
ଆପଣଙ୍କର ସେମାନେ ଜେରାରେ ତାଙ୍କର ଯାହା ଦରକାର ତାଙ୍କ ଫେଭରରେ ବାହାର କରିକି ଆଣିଲେ, prosecution no नुहे जे prosecution गोटे helplessness थिला से position रे. That is how what is to be done in the evidence act, that is there. Chief examination, cross examination, re-examination, यार scope मध्य रहिछि. तो जदि किसी ambiguity हला, then that can be clarified also by way of re-examination. Re-examination रो scope ही होछि सेया. तेणु जदि गोटे डॉक्टर टाकू आपण ताकू तो very easy it is to that तानारे proceeding initiate कर दवा से डेविएट करागला. वर्तमान ताकू जदि पचरा जाई थांदा री-एग्जामिनेशन करी जे बाबू तमे चीफ रे तो या कहलो क्रॉस रे केमती एमती कहउछ सी हुए तो किसी क्लैरिफिकेशन देई थांदा, सेटा न करी ताकू डिसमिस कर दियो, से डॉक्टर को नारी इनिशिएट करो.
That is on record that
so it is the fault of the public prosecutor, but the person who suffered is a doctor. Are you following us?
Yes.
But you have not performed, the public prosecutor has not performed the duty. Re-examination, it should have got the clarification. आपण ताकू कौन पाई आपण जदी वेपन टा अवेलेबल थिला, से डॉक्टर को पाकू से वेपन पठेई थिले, जो जेते बळे से कहउची मु पॉजिटिव ओपिनियन देई थिली बेली, से वेपन तो कोर्ट रे थिला ना ताकू देखैतले से तो कहि थांदा हां या ई वेपन टा
Confirm करते
मते
थे।
प्रोड्यूस करथांदा आपनकर से वेपन सीज हेची एवं एई वेपन मो पाखे प्रोड्यूस हेची एगुडा कहूची मो ओपिनियन एया को देखि मो ओपिनियन देइथिली कोन पई ताकू आनिलेनी तो एमो गुडा ताप द्वारा काहे की मार्क कलेनी आईओ द्वारा काहे की मार्क कले because you are apprehensive that if you would have shown these weapons to the doctor might have said that no, this was not produced before me. एगुड़ाक मो पार प्रोड्यूस ही नथिला एगुड़ाक रे ही परिबनी बोधे डॉक्टर कहि थांदा सेहि पे आपण तम पछ देखैलेनी वेपन
It is the doctor's opinion, neither in the side of
No, no, we
prosecution
are
nor in the
not that.
defense.
We are not on that.
We are not.
We are
To just arrive at
we are conscious of
conclusion.
that.
We are-
It's a opinionative.
it's
all
all
right.
evidence but after
But
all
what was your role? Whether you have discharged your role, that is the question.
आपण कहले ना
What has this-
आपण are you not feeling that the public prosecutor has also not conducted it properly what he should have done आपण एई जो स्टेटमेंट आसिले चीफ रे गोटे कहला क्रॉस एग्जामिनेशन गोटे डायमेट्रिकली ऑपोजिट कहूची सेठी पब्लिक प्रोसिक्यूटर रोल किछि नाही चुपचाप
Should have
रही
confronted that.
आउ से ट्रायल कोर्ट लिखि दबो खाली डॉक्टर अगेंस्ट एक्शन नहीं जो इज इट द जस्टिस
Once my submission, normal submission was the difference of opinion of doctor is there in so far examination and cross examination. The duty is cast on the trial court to verify all those things.
No, he has verified. He has verified, and since he has accepted only the prosecution version, whichever favorable to the prosecution, he has accepted it and stated that the doctor has gone against the prosecution in the cross examination. So let us take an action against the doctor.
See, when this statement was given by the doctor with regard to the fact that a query was made and he has given an answer in positive, which was subject to objection. Is it? So when the objection was raised at that point of time, so nothing prevented. Nothing prevented.
आपण एमओ गुड़ाक थिला ना कोर्ट रे हाँ एमओ गुड़ा नथांदा सीज हेई नथांदा कि आसी नथांदा कुआडे आपण तार नेक्स्ट विटनेस रु एमओ गुड़ाक प्रमाण करूचंती 8 नंबर साखी पर 9 नंबर आसीगला आईओ सबुतक एमओ प्रमाण करै पैराग्राफ 3 रे सबुतक एमओ प्रमाण करै आपण जेतेबेले गोटे आणुचंती एविडेंस तीनटा आई विटनेस को जरिया रे जे एई वेपन गुड़ा करे अक्यूज माने असॉल्ट कले डॉक्टर चीफ रे जदियो टू सम एक्सटेंट आपण को सपोर्ट कला बट क्रॉस एग्जामिनेशन रे कंप्लीटली डिफरेंट कला हमें कोन क्रॉस एग्जामिनेशन टा आखि बुझी दो तो जदि आखि बुझीबु नाही क्रॉस एग्जामिनेशन को मध्य कंसीडर करिबु then equal weight should be given. Chief examination तो गोटे केस विचार होबनी ना हाँ
Page 170 रे डॉक्टर देखिए what he has stated is like this 170 the last
last
Sir,
time
कहली
that-
परा
that
पढ़ेली।
my esteemed brother has pointed out that was objection
Aye.
why it was objected to at
Exactly.
that point of time the public prosecutor's role is that you should have
Exactly.
shown it that to get the clarification that a document एगुड़ा produce हेतला आपण पाखरे कारण एगुड़ा सब मार्क हेजी ना एमओ मार्क हेजी
Aye.
through investigating officer
So I was pointing on that only.
Yes.
You made me slow. You became slow. You did not come to that and you went to Pacha. Horrible. These are all
This is why your lordship is
These
a
are very
very
little.
man counsel.
This is very limited.
That is why your lordship judges and I am only counsel.
We respect your experience, but at the same time, certain thing comes to our notice.
ये जो चेंज होची ना एगुडा होची थॉट प्रोसेस जाउची तेणु आमे गोटे गोटे ऑब्जर्वेशन सेते बेले जो कर दोउचु बेले बेले तांको ये रे को
See, observation टा आगे हमको help करती देगी to find out material.
That is why it is participatory.
Exactly.
Don't take the view that unless that judgment is pronounced and signed, that the judge is taking an adverse view against the prosecution or the defense, and the judge is don't take that. So we are taking note of all these points and we are also examining it.
When it was objected to, court, the public prosecutor should have been concerned.
Yes, yes,
Sir, that is what I was pointing.
Yes, sir. That goes deep into the matter. Before that report was exhibited.
कारण सेठी मिस्टर धर कहीं ऑब्जेक्शन कले रिजन टा होची जदि एगुड़ा क्रॉस एग्जामिनेशन में बाहर था चीफ रे जदि से लाइन टा लिखाई न था ताले हुए तो कही था आज्ञा चीफ रे तो कही थला ना एटलीस्ट से माने ऑब्जेक्शन भी कही ना दी व्हेन ही सेड दैट द शार्प कटिंग वेपन रे एगुड़ा पॉसिबल बेली फारसा फारसा से माने तो किछि ऑब्जेक्शन कलेनी दैट इज हाउ इट हैज बीन रिकॉर्डेड so that is how he has made this subject to objection. तो सेटा नोट हेजी तापर एतिको बाहरी कि नास्तिक एवं कारण मध्य पचरा हेची जे कोन पई एथेर हबनी फारसार इंजुरी फारसाटा होची केमती देखिजन तो एमती तो ए टाइप रो से फारसारे ब्लो हेले से बाहरी करछंती फारसार इंजुरी ले केमिति हबो in case of if we come to page number 172 in case of farsa injury there would be a tail in both the ends of the straight injury so that is the reason why a injury konsi tail nahi I have not found any tail so that is why the bhusa au eta deishanti
that's why the legendary who was cross-examined that we have that is and I am we have also that
I do not know you know or not so many preparation was going on at that point of time we have seen that we have experienced that what a preparation what is the each question they are thinking of whether we should put or not and this that so
if that would be put what would be
the answer
and if this would be the answer, what would be the next question?
Next question. And Mr. Panda is right that at that point of time, the criminal appeals, the contesting appeals, in the High Court, it is hard for 4 days, 5 days, and even more also.
More.
I am telling your lordship, 2 items were there, item 31 and 32. Dr. Justice B.N. Misra was the division bench. For 1 whole year, I used to sit and go back home. They never reached.
Discussion and the question ultimately it is to be appreciated.
See, unless it is participatory, neither we can be emboldened nor you can know what is our mind.
Yes, sir.
So it is very necessary because ultimately we are going to write the judgment. So you must know what is our mind. Accordingly, you will satisfy. Or else if you make 2 queries and you will say that no, we will not come to that.
I mean,
Go on.
but
Go on.
what is required to be answered so that
If the judge would sit silently in criminal appeal, just hear it, put no question, and then with all kind of doubt, reserve the judgment.
Very difficult to
and then
argue the case. Very, very difficult to argue the case.
So, say, you must respond. Right?
We are raising good many points, but which point we will consider remain?
तमरो जहाँ डाउट होची माइंड रे जज रो ड्यूटी होची क्लैरिफाई करियो तो आपण कहिबे एटा तो आपण के अगेंस्ट अछि दे मे गो थ्रू द record and clarify our doubt so that is the duty बसी चुपचाप बसी जो सुन देलो बस तापर जजमेंट
PW4 is Udan. Udanat is at page 149. At paragraph 2, my lords, his specific version is 4 lines from the bottom. 2 to 4 persons crossed me with conversation that Bhagirathi Kaur was murdered. My lords, good?
Yes, yes, sir.
On hearing this, immediately I proceeded to Sarankul PS, informed the matter to the police. On the instructions of the police, I gave a report in writing stating this fact. The police made a station diary entry and immediately proceeded to my village in a jeep. I accompanied them. We reached the village at 9. In the village, the police inquired into the matter and Prafulla Kaur narrated the incident to the police. The latter reduced into writing his information, read over the contents of it to him and took his signatures thereon. They also took my signature on that report. Then he says, the police sees the wearing apparel set, that is pant and shirt, we are not concerned. At paragraph 5 of the cross-examination, my lords may kindly see. Soon after the police reached in my village, searched, inquired Prafulla Kaur. I only accompanied the police to my village from the PS. I had not stated to the police the names of Prafulla Kaur. Police inquired about the incident from Bamana Viswala PW2, Bhagavata Pradhan PW3 and many others, and thereafter sent for Prafulla Kaur. Gramarakhi Sukkara Naik went to call Prafulla Kaur. This Gramarakhi has not been examined, and PW2 and 3 who have stated about the incident to the police, they are Caesar witnesses who have not spoken of it.
That I have stated in the past already.
That Mr. Dhala has also placed before you. And how, my lords, the police inquired about Prafulla Kaur when he has not stated about him?
And beforehand, you say, he came and asked
Huh.
the Prafulla.
କେମିତି ପୁଲିସ ଆଜ୍ଞା ଖୋଜିଲା ପ୍ରଫୁଲ୍ଲକୁ?
PW4 says PW9 accompanied with him to the village and immediately asked for Prafulla. How could he know in that police station that Prafulla is the person who was in the occurrence?
No, we have taken note of it.
Yes, sir.
We have taken note of it.
ତାପରେ କହିଲେ ନେକ୍ସଟ ପ୍ୟାରାଗ୍ରାଫରେ ନେକ୍ସଟ ପେଜରେ the presence of he discloses Jogi Pradhan, Kasinath Pradhan, Hari Naik, Haluri Behera, Brajabandhu Kaur. এটা হচ্ছে brother of the deceased, Brajabandhu. Fakira Kaur, father of the deceased. Bamana Viswala, PW2, Bhagavata Pradhan, PW3 and many others were present. When police reduced into writing the statement of Prafulla Kaur. This again, my lords, is the answer to my learned friend's statement that because the witnesses to the inquest are not eyewitnesses, non-naming of the assailants is of no consequence. If Fakira Kaur was present, Udayanath Kaur was present, and Brajabandhu Kaur was present, all three of them are witnesses to the inquest exhibit 13. And in front of them, the statement of Prafulla Kaur, the eyewitness, has been reduced into writing by the police. The naming in the inquest report that kichi durbutta mane mo bhai ko mar deichan, that raises suspicion that the FIR is anti-time.
This is also signatory.
Yes, and Udayanath Kaur is a signatory to the FIR.
The chief, yes.
He has stated in chief that he has signed on each page of the report.
No, that is there.
Right.
The Udana signature is there in the FIR, in that inquest report.
Right.
It is there and also
In the
And then he also says, police inquired about the incident from the persons present there soon after recording the FIR. And to that effect, my lords, the evidence of PW9 in cross-examination, my lords, is also very important, my lords. Kindly look at page 182 of the book. And your lordship may look from page 181, para 60.
One
1,
Hmm.
paragraph 16. Udayanath Kara PW4, Fakira Kara PW7, and Brajabandhu son of Fakira were the three witnesses to the inquest of the body. I have also recorded the statement of PW4 in the night of 28/6/91. The other two were examined by me after inquest. I examined them on 29/6/91 at 7 a.m. Again, I examined PW4 after inquest. Then your lordship may come to the next page. Para 17. I have noted the substance of the entry made in the SD number 507 dated 28/6/91. Lord, so far as this SD 507 before lunch, that exhibit B by 1, that is not relating to SD 507. It relates to SD 510. That is the information from the hospital that the deceased was received dead.
No, 50 আমরা দেখতো না
507 is correct.
507 tabra
507 is correct.
stationary entry টা
507 ଟା exhibit ହେଇଛି କାଇଁ exhibit ହେଇଛି 510
ହଁ ନାଇଁ 507 ଟା ସେଠି ଅଛି
ହଁ 7 ଟା ଅଛି
ଏଠି এই ସାଇଡ ରେ exhibit ହେଇଛି ମିଷ୍ଟର ଧର ପଣ୍ଡା it has been marked as an exhibit 20
exhibit 20 ହେଲେ ଆଜ୍ଞା ସେଟା ମାର୍କ ହେଇଛି on the basis of the evidence of PW10 ବୋଧେ
କିଏ ଗୋଟେ କଣ କରିଛି ଆଉ
ସେଟା ମୁଁ ଦେଖିଦେବି Now, what he further says here, my lords, is in my CD, third line of para 17, the SD disclosed about the murder of Bhagirathi Kaur. And basing on that information, I proceeded to this point. So the station diary discloses the murder. PW9 also corroborates what PW4 has said, that he heard about the murder of Bhagirathi and went to the police station. There is some distance between village Bodogoroda and Sanogoroda. One road only leads from Bodogoroda to Sanogoroda. In between the distance, no other village intervenes. Udayanath Kara did not tell me from whom he received information that Bhagirathi was murdered. PW4, PW7 and Brajabandhu were the witnesses to the inquest. PW7 and Brajabandhu are the father and brother of the deceased respectively. Column 9 of the inquest report has been filled in by Brajabandhu Kara. It was written by him in his own handwriting. Brajabandhu Kara and Udayanath Kara have also signed in column 9. Column 9 reads that my brother had been murdered through the miscreants. ମୋର ଭାଇକୁ ଦୁର୍ବୃତ୍ତଙ୍କ ଦ୍ୱାରା ହଣାଇ ମରାଯାଇଛି. Brajabandhu Kara and Udayanath Kara had signed in column 9 in my presence. Their signatures are marked exhibit A and A by 1 respectively. Inquest report does not disclose the name of any of the accused persons to be assailants of Bhagirathi. Remarks columns of the dead body challan marked exhibit 14 is meant to depict the full history so far as is at present known, to which I filled up. For that, do not disclose the name of any of the accused persons to be the assailants of deceased Bhagirathi. So he himself admits and says that in column 14, because he has noted that the history so far was not known, he filled up that it does not disclose the names of any of the accused. Under seizure list exhibit 1, I seized only one chappal, though I searched for the other one, did not find the same in nearby place. Similarly, I searched for the other part of the wristwatch band, but did not find the same in the nearby place. Recovery upare para 19, my lords may kindly see the third line. Is a seizure from Subala. During investigation, I recovered some incriminating materials from the house of accused Dandu Pradhan and Subala Pradhan as per seizure list exhibit 8 and 7 respectively, but nothing incriminating was found from the house of any other accused persons, though I searched their house. This, my lord, should be noted. Sukura Naik was the Gramarokhi of the village Sanogoroda at that time. He had not accompanied me to the village from the police station. He was not present in the PS when I made SD entry. I cannot say when Sukura Naik was met by me, but for the first time his name finds place in my CD, recorded at 7:30 a.m. of 29/6/91.
The next morning.
Next day morning. Sukura belongs to village Sanogoroda.
Very
His residential house is situated very close to the alleged spot. I have not recorded his statement or of the statements of any of the family members of Sukura. So the grammar of his presence comes, my lords, only at the time of inquest in the morning.
But PW4 says Sukura was sent.
Yes.
The Sukura was sent to call PW5 before he lost the information.
Right. That
So
is the evidence of
everything
PW.
is topsy-turvy manner in a, if you entirety it is same.
At page 150 at paragraph 5 he says Gramarokhi Sukura Naik went to call procurator.
And that is on 28/6.
I got it. Sum up, Mr. Panda.
My lords,
To reserve it.
so far as the eyewitnesses are concerned, I'll need an hour. Can we do it on Tuesday morning and conclude? And I'll cite the decisions also.
Then
Should give the citation.
Yes.
We would have closed it today and would have given you opportunity to file the written note of submission and citations, of course, by Tuesday. Since Mr. Panda is telling that he will take 1 hour on that day. So on that day, we will hear him and also anything you want to say, but the written note and citations should also be given on that day. Don't take further adjournment. Okay. The hardened part for the already.